Sir, mentioning case number 1, item number 128.
Mention. I want to mention.
Case number listed matters. Case number 2.
Sir.
Thank you.
Page number 2, item number 9 to 18. Page number 3, item 19 to 23. Page number 4, item 24 to 30. Page number 6, item 31 to 34. Page 7, item 35 to 39.
Item 38, my lord. We want to this matter may take up 1 week after I file an amendment. 38, man.
What kind of amendment petition?
Amendment, they have filed counter. In the counter, they have filed another rejection order of the petition of appointment under rehabilitation assistant rule.
When the counter affidavit was filed?
Counter was in read appeal file. In the read appeal matter.
The REIT appeal, they filed the counter.
Yes, ma'am.
This is the opposite party number 1 filed that counter.
Yes, my lord. In that counter, they annexed one document where they rejected the prayer of the petitioner giving appointment under rehabilitation assistance scheme.
Okay.
Rejected. Yes, ma'am. That's why I want to amendment, ma'am.
By your amendment, how can you just withdraw the appeal and we allow you?
No, ma'am. They have rejected in in another order. I challenged the said order and the honorable single judge, my petition was dismissed. I filed REIT appeal. In REIT appeal, they have another order was showing that your appointment under rehabilitation another. Yes, ma'am.
I don't know what is this. So all that you are fixing the matter on 18th. You are Mr. Mahanti.
I mean, Mr. Vishwal, ma'am.
At the request of Mr. B. Vishwal and counsel appealing for the appellant, let the matter be listed on 18th September 2023.
Lordship, item 35, my lord. On behalf of Mr. Pitambaraj may pay for short accommodations. I have taken the consent of REIT appellant, my lord.
What is the reason behind?
Lordship, he is in a part matter in Delhi, my lord.
That is not a good ground for granting adjournment.
Lord, see, he has instruction. I don't have the power in this matter, my lord. I'm just paying for a short accommodation, my lord.
Let the matter be listed on, give a date. No, not date. Is it? Huh?
47.
Have you taken consent from the council?
Yes, my lord.
The request made from Mr. It's in a council. Let the matter be listed on 27 September 2023.
Keep your blessing.
It has been stated by Mr. You are not there, no?
No, my lord. I'm not on record.
All right. Check the party. That counsel for the appellant has been informed and he did not, he has been informed. Okay. All right.
Page 9, item 40 to 42. Page 10.
Lordship, item 42, Lordship. Right, I can leave to mention this matter to take up today, Lordship. 42.
Today,
It was on first day, Lordship.
I have seen this volume of the list, so today it may not be.
My Lordship, can it be fixed in some other day by fixing a time so that Lordship can take up, Lordship? Any other day, Lordship?
Item number?
42, Lordship.
What is the urgency in the matter?
Urgency, Lord, I'm not getting promotion. I'm the verge of retirement, Lordship. On the charge that a criminal case is pending, I have been exempt from the department charges.
Okay.
But, Lordship.
Who is appearing for Ms.
State, Lordship.
State,
State.
Mr. Badoli?
Yeah. Mr. Khuntia is appearing, Lordship.
Anyway, this Mr. Mudali is appearing. We just given an agreed date because we don't like the adjournment to be taken on the next date. Can it be done on 26th of September, Mr. Dalai? Little far away.
Bhara, Lordship. Begin, Lordship.
11th is a lot of matters. 11th September. 13th. 13th also.
His age is 56 years or it has been incorrectly mentioned?
20.
Lordship.
Yes.
Is his age 56 years?
No, Lordship.
No.
Further retirement only.
It appeal that age.
Just I'm fixing it on 26 as a fixed item at 2 p.m.
26th.
Because otherwise there are 77, 78 matters. There's no chance.
Lordship.
As agreed by the council for the parties, that the matter be listed on 26th of September 2022 at 2 p.m. for hearing on merit. Mr. P.K. Moduli, the additional government advocate, appears for the appellant, whereas Mr. S.K. Dolri, United Council, appears for the sole respondent.
Lordship. Correct.
Case 10, item 43 to 47.
No,
There is an interim order.
no, Lordship. But I have
Just-
IA for modification of the order.
No.
That is yours.
Because their writ petition has been dismissed.
No, Lordship. In fact, my appeal.
Oh,
My requisition allowed, but on their appeal, Lordship, I have got one promotion, Lordship. I have taken one promotion.
so you have got the interim order. Then let us check it.
No, they have not taken. No, they have not taken interim Lordship. Rather, in their appeal, I have taken a relief that I will.
He has been given ad hoc promotion.
Add a promotion, Lordship. That is.
Case 10, item 43 to 47.
Criminal appeal is pending.
Page 11, item 48 to 52. Page 12, item 53 to 56. Page 13, item 57 to 62. Page 14, item 63 to 66.
Item number 66, my lord.
Yes.
I pray this matter may kindly be taken up because the interim order is operating against me. I am not able to function. The shop room which was allotted in my favor, my lord. I have deposited the entire amount and lease deed has already been executed. But by virtue of the interim order, my lord, I could not enter. I could not, my lord, operate the shop room.
Let us see. Comment 2. Let us see.
My lord.
At page 15, item 67 to 70. Page 16, item 71 to 77.
Item 77, my lord.
Yes.
I pray for taking up today, my lord, because I am not getting my dismissal order set aside and remanded back to the dismissal authority, but they are not paying the success allowance.
All right. Who is appearing for this?
Government.
But there is no provision. Rule prohibits, and that rule is under challenge.
Which rule prohibits?
Police manual, that is under challenge.
There is no subsistence allowance under the police manual.
No.
It is there, my lord. I will show my lord is there.
Then why are you challenging the rule? If it is there in the rule,
330. Let us
I am not ready in that matter.
See, tomorrow-
State has also not filed because wires of the rule is under challenge. Counter affidavit has to be filed by the state regarding validity of the rule.
All right, then what to do? 27 September.
Yes.
I'll be.
No, 23 matters. I did not look at the age of the case. They have not filed the counter affidavit.
The counter affidavit which has been filed, that only justifies that this is the prohibition as a result of which we cannot grant. That rule itself is under
Mr.
challenge.
Mollik says there is a provision for granting subsistence allowance. Then why is the question of challenging the rule?
Yes. He can explain why he has challenged the rule if there is no such prohibition.
Relying upon that rule in misinterpreting my lord, they have denied they are not paying no order is passed. They are not paying the subsistence allowance, my lord.
No, according to them, there is no such rule enabling them
Yes.
the payment of
I will
subsistence.
show my lord, Orissa's service code and the CC rule are applicable, my lord.
Well, he is a police officer belonging to the police cadre. And their service condition governed by the police manual,
As per
Odisha
the-
police manual. Now that prohibits That is why he
Law
has
settled by
challenged
the
the
Honorable
rule.
Supreme Court, I'm entertaining my lord. Because as per the law settled by the Honorable Supreme Court, I will show the.
No, that's the principle that we take care of your challenge, that time we'll decide. But at present, government says that we don't have any such rule giving subsistence allows, but this is a rule of the natural justice. You are putting someone in this serious jeopardy so that he cannot defend his case properly. Better we fix it some other day.
No, now he has been reinstated. Now he has been reinstated.
No, I have not been. Proceeding is continuing.
No, whether he has been because
The proceeding is are you continuing on suspension?
No, my lord.
You have been reinstated.
Reinstated.
Yes.
so what is the question of
Set aside, my lord. I will not be
That
reinstated.
There is no
period, he is
urgency.
claiming for that
No,
period.
on 27th of
Which has-
My lord, no, I have not been reinstated. I have
request of Mr.
set aside the.
Timothy,
Little say, purpose that, my lord.
preparing for the state opposite parties. Meanwhile, the opposite parties shall invariably file their counter affidavit. As this court will not provide further opportunity. It will come on 27th.
No, I refer.
Mr. Malik, there is no urgency. Mr. S. Malik, counsel, appears for the petition. You are reinstated now.
No, I have not been reinstated. Matter has been remanded for fresh inquiry, my lord.
Yes.
Inquiry is continuing, my lord.
You have not been reinstated.
No.
You make a statement that you are.
So you're still under suspension or allowed to join?
I have not been allowed to join, my lord.
All right, let us see in 27th. Let them file also the counter.
Page number 17.
My lord, item number 76.
Ah,
My lord, item number 76 relates to one of the disengaged court managers, and my lord has been pleased to direct for listing of this matter on 5th of September at 2 p.m.
all right.
So I pray that this matter may be also taken up at 2 p.m. on 5th September along with other matter.
6th September.
5th.
Item number?
Item number 76.
76.
With the request of Mr. Devashish Patnaik. Counsel appearing to the petitioner. Then the matter will be listed on 5th of September with analogous matters. All right.
Page number 17, item 78 to 86. Page 18, item 87 to 94.
Yes, item number 89, my lords. Item number 89 on the last occasion, the lordship was pleased to issue notice, my lord. That is the state to file counter. In the meantime, no counter has been filed. Lordship may fix a short date. In the meantime, the counter may be filed, my lords.
They have not filed the counter.
No, not.
Who is appearing for the state in this matter?
No, I am.
Mr. Kunti, how much time would you require?
2
And
weeks.
this is the last opportunity.
Yes, my lord, 2 weeks.
This is the matter on 26th of September 2023. For the request of Mr. M.K. Kunti and the additional government advocate appearing to the state opposite parties. In the meanwhile, the state opposite party shall invariably file their counter affidavit as this court will not provide further time for filing the counter.
There, your lordship see noting, your lordship see, there is a noting in item 89. Perhaps you have not taken steps to implement the government as a party.
Already implemented.
Noting, noting. State party person.
Yeah, already you filed,
I'll,
this is 88?
89.
89.
Okay.
Page 19, item 95 to 97.
You are Mr. Sahu, no?
He's a 8th party, my lords.
A3 party, yes. Appears for the petitioner. Yes.
Page number 20, item 98 to 103. Page 21, item 104 to 112. Page 22, item 113 to 119.
My lord, 133, my lord.
Page 23, item 120 to 126. Page 24, item 127 to 132. Page 25, 133 to 136.
Item 133, my lord.
Yes.
In this case, my lord, call for a report from the circle judge. I have personally visited to circle judge Salapur. Yes, submitted. CRL 190, one of those.
Whether that report has come.
Of course, he has given a memo to me. I have supplied my lord.
This appeal has become infractuous. He has been released prematurely.
Already increasing 14 years, 5 months, he
No, this is jail's working. Anyone is appealing to the state in this matter? Have you just gone through this report? He has been.
No.
Just check the report.
No report is available with you.
No one. But after this memo, my lord, he has already communicated my lord's office. You see.
This is the problem. Must be down below, it must be written that communicated.
Have done for the report, pilot. No more. The appeal is.
Or would you try to verify the report? No, because this is a photocopy, that is the whole difficulty.
I'll check up pilot.
Come at to just talk to this senior superintendent circle jail cutoff because it is here. Call them to bring the original copy of the report. It will take it up at 2. Please come, huh?
Check in the office also in case it has been received.
You just take back and at 2 you produced it before us.
Page mentioning over.
Well, I may pardon to mention one gratuity matter assigned to Honorable the second Mahapatra. But since he is concerned, this matter may not be listed before the lawsuit. Maybe you say any other bench matter.
I have mentioned before the.
No, I have given 4 memos to before we are unfortunately not
Judicial.
Have you given?
Yes, madam. 4 times I have given, ma'am.
Pardon, Lordship. On the letter, Lanka also for removing defects sought urgently.
Pardon to mention, Pardon to mention, my lord, specific adjournment was for today. It was not listed today.
Pardon for mentioning a matter, my lord. CMAPL number 251 of 2020. The writ was dismissed for non-prosecution. Twice I have mentioned before Lordship Justice Muralidharan, but it could not be listed, my lord.
Grateful, my lord. It's a case of dismissal minutes. Honorable signature granted for reinstatement minutes. As the federal stated before read appeal. Because of the pendence of the read appeal minutes, the petitioner are not being re-engaged minutes. The previous matter to be taken up.
By your memo, we will not fix up our date for early hearing, file a proper application. This is not done. You show the ground and file a proper application for upgrading the matter. By memo, we can list the matter.
I am praying for listing of this, but this read appeal.
But yes,
WPCRL.
And the next date is fixed.
But if fresh admission, sir.
Oh, fresh.
One fresh admission to WPCRL. In action of police, my lord.
To make a mention, my lord.
Previous admission, read appeal, my lord. Yes, my lord.
Well, let's rate appeal fresh admission was within 2 minutes. Lakshmi, well, there is urgency. May I pray for tomorrow minutes?
Yeah, okay.
I'm ready.
One rate appeal you'll also do. Not fresh admission.
My lord, pardon to make a mention, my lord, that here it's an interim order passed by this honorable court as being under challenge, my lord, because the interim order partakes the characteristics of the final order, and our maintainability petition before the honorable tribunal would get infructuous, my lord. My lord, my humble prayer that the matter is actually posted tomorrow before the tribunal. If tomorrow this writ appeal can be accommodated on an urgent basis, humble prayer.
Pardon to make a mention, my lord, one fresh admission matter, PIL.
Pardon, your lordship. I'm mentioning a single bench matter, your lordship. Proposed to contempt of court matter, my lord.
What's the single bench matter before us?
Your lordship, twice mentioned before the roster judge, your lordship, but it's not listed, my lord. And
have you registered before the deputy register judicial?
Yes, my lord, more than 5 times, your lordship. And your lordship, specific urgent matter, almost 20 matters, specified matters, your lordship, that also not listed even after specific direction of this honorable court, my lord. All proposed to the single
list of the cases we check. What is the kind of a mention you are making? You're making an application.
No, my lord, I'm not. I'm mentioned the details of the cases, your lordship, specific urgent matters, my lord.
Give us a list, not these applications.
My lord.
This is the form of application. Give a list. All right, list of the cases. Then we look into this.
Memo also there, my lord, in a content matter.
Memo would be better.
All right.
Individual file and.
Gratefully.
Lordship, in fact, this matter assigned to honorable single judge, but I have taken liberty, lordship, to move here because my audited 17/8/23 leave it has been granted to honorable chief justice. But here, lordship, since last
Single judge has granted liberty
Lordship.
for the chief justice.
lordship, that is there, lordship.
That you just sent one of your associate to the registered judicial. You will place before it because it is a matter order to be passed in the administrative side, not in the judicial side.
Lordship, but urgency, lordship, since last
Today itself you go there and then
Lordship.
yes.
I don't to mention, my lord. Page mention. Here, item 32.
Mention is over now.
Over. Weekly daily list fresh admission item number 1.
Yes.
Lord, wait, please, your lordship.
Yes. Yes.
The question, this is a case of assessment on the basis of audit visit report. So your lordship knows that in that act, actually, there is a provision for audit visit, and the commissioner has got the power to make an audit visit. The commissioner under Section 5 has the power to delegate to somebody, some other official, to make an audit visit as well.
Is this a ground, Mr. Minister?
But
can you say the principal cannot visit what his delegate can visit?
no, it can be delegated that statute.
Can be delegated, but whether that debars the principal to visit any.
No.
That's all.
But here the question is,
yes,
delegation has been made, notification has been made, Marad. The notification has been made on a particular date, and the visit is prior to that.
Okay.
The question here is that in the absence of any notification of delegation, whether the Assistant Commissioner of Sales Tax or Commercial Tax has got the power to make a visit. In fact, this question I raised at the time of second appeal, my lord. This is a question of jurisdiction goes to the root of the matter.
Yes.
But that objection has been discarded by the full bench. Full bench. That is the subject matter legal point that I want to raise before Lordship. Because in Odisha, the commercial central sales tax, Odisha rules, there was no provision prior to 2015. So it was first time incorporated the provision of VAT Act. So these are the provisions to be made applicable. So this came into force on the basis of the notification as well. Same notification, Rule 10 and Rule 12 has been amended. If you also kindly look at Rule 5 of the VAT Act first, sorry, Section 5.
Yes.
Section 5 says, subject to such restriction.
Yes.
I think it was
I got it, you did it.
Section 5, that subject to such restriction and condition as may be prescribed, the commissioner may, by order in writing, delegate any of his power and functions under this act or the rules to any person appointed under Sub-Rule 2 of Section 3. And any order passed by such person except the power so delegated shall be deemed to be an order passed by that person. It is commissioner. But 3.2 provides these are the officers who can be delegated the power. But this was first time incorporated in 2015 July. Just you kindly look at the notification I have filed.
At page?
At page 109, it says they exercise the power conferred as a Section 5 of Odisha value-added tax.
This is a notification of 9th February 2007.
It is 9th February 2007.
No, you have mentioned 2015.
So it was subsequently it has been withdrawn by in 4th April 2009. I have given both the notifications. But this has been done in January 2007.
Yes.
To be precise, if you actually looks at the date, audit assessment report was made on 10th September 2008. The date of assessment is 16/1/2007. 16/1/2007.
Yes.
Obviously, it's prior to the date of delegation.
What is the order of assessment?
If you also kindly look at the order merit. But here, what has been assessment made on the basis of such audit report, audit visit report, that was set aside by the appellate court. Appellate court said, no, it's not correct. And subsequently in the...
Where is that audit report?
Well, kindly see that one. Annexure 1 is the first order merit. At page 70.
Is Annexure 2?
Annexure 2 is the appellate court order.
Assessment order. No, it's the order of assessment dated 9.
So Annexure 2 is the assessment order.
But this is dated 10.
At page 71.
That is dated 10/9/2008. Not 2007. Dated.
So date is mentioned for lordship. Date is mentioned for lordship. Can you see?
Period.
31/1/2007. There's a period between 1/4/2005 to 31/1/2007.
To the period.
That's the period. The report is on 10th September 2008, top merit.
Yes.
But a date of assessment is at page 72 merit. if you see fifth line, the officer of the enforcement wing visited the place of business on 16/1/2007.
Yes.
Now, I got the fifth line from the top.
Yes, Senate.
In the
Yes.
assessment order. 16/1/2007. That was prior to the delegation of the notification, delegation notification in section 5. So this is the sole basis on the basis of which actually a report was made. On the basis of the report, the assessment has been made.
Yes, Mr. Pari.
Yes, my lord. That question arises for consideration, my lord. Let me admit on that question, I will answer.
You want the admission?
Yes, my lord, it has not been admitted.
No, you can form the questions and
My lord, yes, this arises for consideration here.
all right, we can admit and decide the matter
Yes.
right now.
My lord,
Right now. Because it's apparent on the face of law at the time these other officers did not have the power. Delegation only took place by this notification on the
February 2007.
February 2007, 9/2/2007 is exactly the date. So why is there authority to inspect someone?
yes, my lord, the assessment records need to be seen, my lord.
But they have clearly mentioned in the assessment order that
Yes, my lord,
the place of business on 16/1/2007.
Yes, my lord, that I have checked.
Right.
Lord, give me a short date, my lord, then I will come back, my lord, with the assessment records. Because assessment records is
sure. Learned counsel. Senior counsel listed by Mr.
VP Mark.
VP Mahanti, learned counsel for the review petition. Sorry, revision petition. So, admit this revision petition of the following substantial question of law. Whether the officers of enforcement wing had any authority of inspection the place of the dealer on 16/1/2007 in view of the position, in view of the legal position that Section 5 was incorporated in Orissa Value Act 2004 by way of amendment on
February 2007.
9th February 2007. Question mark. Issue notice since Mr. S.S. Pari on it.
So one more ground is there, if your lordship kindly appreciate.
What is that ground?
One more ground, because since your lordship is admitting it, page 26, lordship kindly see. Ground number B, my lord. The period of assessment is 1/4/2005 to 31/1/2007. But the question of audit visit came into operation from 6/7/2006, by virtue of which actually the amendment has been undertaken. Rule 10 and Rule 12(3) has been came into force. But it is prospective, it cannot be retrospective. So this power has been
following substantial questions of law. Let's make one. Is it that page?
So page 26,
Capital B, question number capital B, my lord.
Capital B, page 26, capital B.
Is 26 of your petition.
First time brought to the statute on 6/7/2006.
And to whether the audit assessment made under section 12(3) of the CST will make it all rules from 1/4/2005 to 31/1/2007 as carried out by the assessing authority is permissible in as much as the said rule, this rule 12(3) of the CSTO rules has been incorporated on 6th of July 2006 by the Central Tax within bracket Orissa Amendment Rules 2006 and notify by due notifications. Issue notice since Mr. S.S. Pavi and Standing Council, City and GST, APS and OS notice for the revenue, no formal notice is called. Do you require extra copy? You have not filed the certified copy also, Mr. Mishra?
Sir, I have prayed for
you should have pointed out at the beginning. I number 187.
Those IAs have been allowed previously. On the last order, those IAs have been allowed. Dispensing with has been allowed.
Sir, can you have a look at the order dated, who date order dated? 24/4/23, my lord.
Yes.
But IA 187 of 2018, I have filed the certified copies of Annexure 2 and 3.
All right.
That operation of Annexure 6 be state, my lord.
Just no coercive action till.
No coercive action. Progress.
27. In IA 187, Art 7 says, both the parties, council's name, is an application for staying the operation of the impugned order. Dated 18/5/2018, caused by the full bench of Orissa Facilities Tribunal in SA number 29C/2012/2014. The revision petition has been administered. There shall not be any coercive action against the petitioner during the restoration. Is the matter on 27th of September 2023? Yes.
Item number 2. Item number 2
What is the purpose? Why 15 days time? Why do you require 15 days time?
Yes, sir. Defect.
For removing defects?
How much more time?
You are Mr.
Ajit Kumar Sahu.
The request of Mr. A.K. Sahul and Council.
That means there's no urgency. It is being adjourned from April 2023.
Let the matter be listed on 27th of September 2023. In the meanwhile, the defects as identified with the registry shall be removed. No further accommodation for the same purpose will be provided by this court. Next.
Item number 3.
Milan by single bill. Me adjourn 1 more time.
Let the matter be listed on 26th of September 2023. What is your good name?
PR Pora.
Huh?
PR Pora. PR Pora.
Now, his appearance instruction, Mr. A. Marginal and Council opinion was the appellant. Even the next state, no representation for the appellant. No.
Item number 4.
No further recommendations. Just this line, first line, no? It's
Here, the inter-court appeal and on single judge, whereby the single judge, though initially issued notice and directed to file counter, and the state has already filed their counter and also I have filed rejoinder. But thereafter, you also kindly see the order, my lord. On my lord, page annexure 5, page 76. When the matter was listed on 6/4/2023, the single was directed to file an affidavit by the petitioner that explain the reason for challenging the order of 2016 and filing petition 2022. Even though in the pleading, they have in the petition, the appellant have already stated the reason for filing the petition 2022, because earlier after 2016, he has filed way in 2017 before the tribunal, and that tribunal way 2017 has been transferred to this whole court in 2019, and thereafter it was listed. And also kindly see that order, for the moment. Page 53, that way after transfer has been disposed of on 12/8/2021, granting liberty to the petitioner to file a better application with better particulars. That is page 53. And pursuant to that, this order, page 53, the present petitioner filed the petition 2022, challenge the prayer to claim for triangular scale of pay from the date of passing of duty qualification. Now, on single judge, dismiss the despite filing affidavit, explain the reason. Dismiss the application that not inclined to entertain the petition so filed against the impugn order after 6 years of passing of the same. That is page 96. I have filed a detailed affidavit, explain the reason that in 2016 order, I have already filed original application in 2017, and that way was subsequently transferred to this court and disposed of, granting liberty to the appellant to file a better application with better particular. And accordingly, 2022 writ petition has been filed by the appellant. And though the single initially convinced and issued notice and state has filed counter, I have also filed rejoinder. After completion of the pleading, my lord, the single dismissed the application on the ground, my lord, page 96, only ground that you have challenged the order of 2016 filing after 6 years.
Yes, who is appearing for Mr. Mudali?
I am appearing.
When a liberty was granted to a petitioner to file a fresh petition,
yes,
during the date of this disposal order, till then
let him supply the copy of this way so that I can verify, because that has not been annexed.
Which way?
Lordship can see page.
No, the order is there.
I mean,
page 53. This WPC OSC 2023 of 2017.
Yes, I have included, my lord. That is my lord. I'll see in my affidavit. Annexure 6, page relevant page, my lord. Page 83. That are already included, and that was also filed before the single judge, pursuant to the order passed by on 6/4/2023. Explain the reason by an affidavit that is filed on 16/5/2023 before the single judge.
Yes, your lordship may kindly see the prayer at page 91.
Okay.
Paragraph 7. There was no challenge to 2016 order.
Because, my lord, in 2016 order, there was no complete denial by the authority with regard to the.
That order is at page 46, 26/6/2016.
Lordship, kindly see that order, annex page 46, paragraph 4. that by letter number 18109 dated 21st May 2016 of Director of Secondary Education Odisha, it is instructed by the opinion number 3 to take decision regarding allowing TG scale of to the applicant under the government rule. The director already directed to inspector school to allow the TG scale. Thereafter, as no rule yet was implemented by the government regarding payment of TGT scale of pay with effect from passing of BEd to LSS teacher, the respondent 4 is unable to allow the said benefit to the applicant.
Last line, Your Lordship, can see. In view of the above, the representation of
that is why
no merit.
That is why when the matter was listed after transfer, that is page 53, the Honorable Single just pointed out, unless you challenge the order passed by the authority, your claim cannot be considered. Therefore, you are liberty granted to file a better application to better particular. Page 53, that is why the Honorable Single just granted liberty to file a better application with better particular by challenging that rejection order dated 22/6/2016, and accordingly I filed writ petition to 2022. And now after the pleading is complete, after filing of counter, they have not stated in the counter with regard to delay or with regard to challenging after 6 years, and I have filed my rejoinder stating therein.
Mudali, that is better set aside the order of the land as single judge, place before to pass an order on merit.
Because my
So can see two, page 91. What was the relief prayed for? There was no relief. Challenge questioning the legality and validity of order dated 26/6/2016.
That is why my liberty was granted into
no. Thereafter, Your Lordship, can see this order passed by the Honorable Single Judge at page 53.
Yes.
Well, there was no such contention that I will challenge and I am withdrawing this writ petition. There are no such observation.
Specifically, my Lord, also kindly see my writ petition.
And you just come to the relevant part of the judgment whereby you are they claim this prayers in the present this appeal.
My Lord. The prayer in the writ appeal, my Lord.
No, the writ petition.
My Lord, writ petition. I have enclosed entire writ petition. Also kindly see.
2017.
Page 27, my Lord.
Yes.
My Lord. I am prayed for passing of that order of the inspector school dated 26/6/2016 and further prayed, my Lord, to release, allow train graduate scale of pay with effect from 9/3/83 in petition. That is the date from which the petition acquired
the principle relating to granting any pay scale.
This is 2022. So this prayer which he is now placing, that is filed in 2022. And 2017 which he have filed, there are no such challenge.
No, forget about all these things.
Yes.
2020, the basic prayer made in this writ petition is to grant him a particular pay scale.
Which was rejected in 2016. That prayer was rejected in 2016.
Why is there order judgment?
That is the page 46. Page 46, that is the order.
Page 46.
Yes.
Earlier, my Lord, 2014, I approved the learning tribunal in the first case, my Lord.
The nature of order they have passed.
My Lord, page 46, Annex 10 to the writ petition.
May place. This is office order number 7233 dated 22/6/2016.
Yes.
Honorable OAT Cuttack Bench Cuttack by the order number 5 dated 21/2015 passed in OA number 2838 of 2014 filed by Ravindra Mishra and others have ordered as follows. Respondent number 4 is directed to consider and dispose of the representation of the applicant as at Annexure 7, keeping in mind the contents made in OA and Annexure 5 within a period of 1 month from the date of receipt of the copy of this order. It is pertinent to mention here that the tribunal has not gone into the merit of the case and the respondent number 4 is at liberty to pass appropriate order after going into pros and cons of the matter. Pursuant to liberty in the aftersaid order.
This is 46 you are referring to Annexure 10, I think.
Yes.
Annexure 10 is an order of the district education officer.
Yes. Well, that is challenged in 2022.
Up to 2016, my Lord, the only reason assigned by the authority
that kindly allow me.
Where is your writ petition?
Yes. Well, this page 46, you also can say bottom. Well,
yes.
Bottom was communication to the petitioner.
Paragraph 4.
Yes, paragraph 4, last line, in view of the above, the representation of the applicant deserves no merit and is hereby rejected and the way disposed of accordingly. Next is the communication made to the petitioner. in 2016. Now you also can see that in 2017 he filed the way. Now that prayer is appearing at page 91, running page 91.
No, my question is definitely it is a belated writ petition.
Yes.
But it is regarding prayer to a particular pay scale.
Yes.
Right? If he is entitled to particular pay scale, that every day cause of action will arise because he will be deprived. That is the state of Madhya Pradesh versus Srivastava's case in 2009. Every day cause of action will evolve. But what is the protection to the government? Finance has been given that the petitioner cannot claim more than preceding 3 years pay and allowances. So that is the protection to the government because this 3 years has been taken from the Limitation Act for the money source. So the question definitely requires an examination whether he is entitled to that pay scale or not. If he is entitled,
since 2016 he is aware that my claim has been rejected. 2017 he approached the court but did not challenge. Well, had he not challenged in 2017, the situation would have been otherwise. Well, he approached the land tribunal in 2017, but preferred not to challenge that order.
Okay, but pay scale was also asked in those petition?
Yes.
No.
Yes. You also kindly see page 91, that way. Where? My non-senior already placed that prayer, my lord.
And pay TGT scale of.
Yes. There is a prayer to grant of TGT scale of pay. Because the authority said, my lord, that since no rule has been framed by the government, therefore a claim cannot be considered. Therefore, I prayed to frame a rule as also pray the TGT scale of pay in 2017 way.
So
that has been ultimately transferred to this court and liberty was granted to file a better application to better particulars.
And single judge by the impugn order has directed you to approach the government to frame appropriate rules.
But
those rules are not there.
No, my lord, because I am relying.
Absence of rules can be granted.
Now, so kindly say I am relying on the document, my lord.
Source of that you are entitled to the.
My lord, page 57, my lord. My source, my lord, page 57. Annexer 15 to the writ petition, I have enclosed the entire writ petition of the annexer. So kindly see page 57. That is the government resolution dated 1st December 2012, my lord.
Yes.
And the relevant page, my lord, kindly see page 59. Because my cause of action arose after 2000 this resolution, my lord. So kindly see Roman 4, my lord, towards bottom, page 59. Fixation of pay classical teachers. On fixation of revised common qualification as per para 1, the classical Sanskrit teacher possessing common qualification shall be entitled the scale of pay at par with trained graduate teacher scale of pay. The pay of such classical teachers shall be fixed notionally under Rule 74B of the Orissa Service Code, but the pay of classical teachers who have availed TBA benefits also, that is not important. There is a clear resolution, my lord. I am entitled to get the TGT scale of pay after on acquisition of the common qualification. And pursuant to that resolution 2012, my lord, I have filed a petition, original application 2014. That original application was initially disposed of by the land tribunal, directing to consider my representation. And that was one, after filing of contempt petition, that was rejected in 2016, saying that even though the director already recommended my case, but since no rule by the government, therefore the case cannot be considered. Accordingly, I filed 2007, immediately I filed 2017, my lord, that is page 91. Before the law tribunal, with the prayer to frame necessary rule and also pay a TGT scale of pay with effect from passing of BD qualification. And that over 2017 ultimately transferred to the High Court after abolition of the tribunal. And also kindly see the page 53. Non-tribunal, this High Court held, my lord, unless you challenge the order of the rejection order, your claim cannot be considered. Therefore, my lord, also kindly see. After some argument or advance by non-counsel petitioner, he made a prayer to the petitioner that permitted to withdraw the petition with the liberty to file a better petition with better particular. In view of the above submission, the petition is stand disposed of as written with the liberty aforesaid. And accordingly, I filed 2022 petition by challenging that 2016 order as well as also claim for TGT scale of pay. And apart from that, my lord,
whether this decision granting pay scale, is there any administrative circular to grant them?
Yes, when I page 15, I'm just not placed, my lord. That page 50, page 57, my lord, annexer 15, page 57. And apart from that, recently, my lord, this High Court already decided the issue with regard to that, you also kindly see the judgment. Though it is almost single judgment, but reported, you kindly see that judgment I have included in my rejoinder. That is, my case is squarely covered by that judgment, my lord. Where, my lord, the almost single judge relying on other judgment passed earlier, my lord, in the case of Madhav Kumar Polo as well as Jaswant Mandi, allowed the similar claim directing to pay the TGT scale from the date of passing of BD qualification. That is internal page 11, para 8 of the judgment. May I permit to place, my lord?
No, I just want to see the principal rule. That is actually this. Otherwise, because these are things that entitled to this such and such a declaration, what is the principal rule from which this granting this special scale of pay for the TGT teachers, where from it comes? What is that rule?
Rule they have not framed, my lord, because only
by which this special pay has been declared.
My lord, that is by page 57. That circular I have just now placed, my lord. Page 57. That is the government resolution dated 1st December 2012. And the relevant page, my lord, page 59. On acquisition of common qualification, that is the BD qualification, a classical teacher is entitled to get the TGT scale of pay. That is page 59, fixation of classical teacher scale of pay.
You are reading to page 59?
My page 59 towards bottom, my lord. Roman 4, my lord, fixation of pay of classical Sanskrit teacher. He says, my lord, on fixation of revised common qualification as per para 1, the classical Sanskrit teacher possessing the said common qualification shall be entitled to the scale of pay at par with the trained graduate teacher in terms of the scale of pay. The pay of such classical teachers shall be fixed notionally as per Rule 74B of the Orissa Service Code. For the first time, 2012, the government introduced that circular, and after that, I have approached the Law and Tribunal in 2014. And even though the director recommended my case, the OP number response number 3 rejected on the ground that since no rule has been framed by the government, therefore you are not entitled. And the issue has already been settled by the laws. You kindly see the judgment.
Mr. Muduri, are you fully prepared today? Because only issue that we'll consider.
That part, because on merit, because I am not prepared. Because this
has to be decided whether
yes, I'll get ready. But the circular which is being placed, you can see that page 57. Well, that is in respect of Sanskrit teachers. Petitioner is not a Sanskrit teacher.
Yes, petitioner is a Sanskrit teacher, subsequently observed as a junior assist teacher. That is my entire claim. You should kindly see.
Is it claiming to be the Acharya on this? And that has been declared by the circular. Can it be taken up tomorrow? We just go through the files.
Some more time because I have to call for the officer.
I'm marking it hard in part, 1st September.
Yes. One more document, annexer 5 to the web, based 35.
Mr. Songlam,
instead of past, can it be on 4th?
Monday for the petition appellant in part that the matter be listed on 1st September.
4th, Monday. Well, it's a Friday, past
4th September 2023. For continuation of hearing, Mr. P.K. Mudalil, an additional government advocate, is appeared for the state opposite parties. You just produce the judgment. Well, the kind of a judgment doesn't help the court much because it is a particular case, particular fact, because here is another person.
But the sole issue, my lord, whether from the date of acquiring the BED qualification, LSS teacher is entitled for BED scale or not. That is the only
next state.
Item number 5.
May I please, my lord?
My lord, in this case, there are two defects, my lord. As per my lord direction, I have rectified those defects. That is page 11. That was not legible. I have produced that legible copy.
But the 21st of August, it is a note of 17th August shows the steel defect number 11 and 20.
No, my lord, that was because I filed the petition, miscase for acceptance of a consolidated petition, inserting all the defects, removing all the defects. With my consolidated petition is allowed, then the defects, they will correct the defects. Because they are in the remark, since there are two defects. My lord, may kindly, I am inviting my lord's attention to page number 11.
Yes.
That was the not legible copy. Now, in the consolidated petition, I have annexed this copy, legible copy, page 11. Page 11.
The problem is that you are enclosing all the legible copies to your consolidated writ petition.
By separately, I have filed that.
You should separately file it.
Separately, I have filed, my lord. It is there. Thereafter, I included all the.
When have you filed separately?
My lord.
When?
I have separately filed page 20 to 24 English translated copy.
And when filed in the registry, we are asking the date.
It is on 17th July. I have already filed this 20 to 24. That is English translated copy.
This.
On 7th, you had been asked defects.
My lord.
So on 17th, you filed.
Yes, I filed that the defects. That is the page, that is the annexer, which was in Yodia.
No, but on not case again, defects were shown, you were asked to remove.
My lord, since I have filed the consolidated petition, my lord, I can tell you one day time. I shall sit there and rectify the defects.
May I point one thing? My lord, may kindly see the IA which has been filed for amendment. There is no schedule.
No, we are not passing any order on any of the petition. We are just granting time.
Then who? But the amendment was allowed.
No, amendment has not been allowed.
Then how consolidated petition? I can't understand.
Yes.
My lord, taking it.
My lord,
apprehension. Then we can pass the order.
In the meanwhile, the petitioner shall. Remove the defects identified with the registry. No further recognition made for the same purpose. All right, next.
Item 6. Item 6, there the repeal contractual rules, rule 4, which violates is challenge ballot. Last occasion, they have filed a common counter adopted in all the cases. I am permitted to file the rejoinder reply.
All right.
If you accept my permission, item 10, 13, 14, 15, I am giving a seat.
Yes.
All these matters I am appearing at. In all cases that filed counter, I am filing rejoinder today. One counter. That filed one counter, they have adopted that counter in all cases. I am filing a rejoinder today. But in the first case, you also see there is an application for amendment, the item 10.
Yes.
That is the amendment during the pendency of the writ application. Consequent upon that rule, which they have claimed, which is the subject matter of challenge, they have made a SOP. So that is the only consequential relief we have claimed for. That is, you will allow that application, or that will be considered at the time of hearing, that you also do.
Give you numbers.
Yes, I am giving numbers. I am giving slip too.
And you are appearing in which matters?
I am appearing. He is appearing item.
I am appearing for 6, 7, 8.
6, 7, 8. Mr.
I am appearing. I am giving slip. Number of cases are there. Today's list.
Similar matters are 6, 7, 8, 10, 11, 12, 13, 14, 15, 16, 17.
My lord, item 17 notice has not been issued, my lord.
Similar,
No notice required, but
all these matters are similar.
adopted.
Also, item 79.
I'm going to that.
Let Mr. Pakhuntia says that will be better.
Yes.
In 17.
Then, my lord, it starts from 76. Sorry, my lord, 70.
Just one. 17, just we issue notice.
My lord.
A swine and council.
Notice showing.
Not necessary. That will
The similar matters. In the similar matter, this court has issued notice.
that they go to home. Yes.
Return vote on 23.
But may I suggest one thing? I think all council will agree. Let's just fix up a date which will be convenient to us.
27th of September.
Other matters
Can it be little bit early? The point is very limited. I think all will agree. But one case will cover all the cases.
Situation, our board is very, very congested.
I can't precise your answers.
So let it be on 27th. Let us try, give a big try. So that the matters are over in the 27th.
So what I'm suggesting, if you also will keep it in between, suppose that is something, then it can be adjourned. Yes. That will
What
be.
date? We don't have any other date before that.
In fact, the judgment of one case will cover all the cases.
Let it be come on 27th. Why they are filing a rejoinder in course of the day. So I have to take instruction on that.
All right.
Let it come on 27th.
Let the rejoinders be filed by.
My learned senior has filed, others have not filed. They must.
They have not filed, they will file. 14/9/2023. Any additional affidavit by the state shall immediately be filed by 22nd of September 2023. It is made absolutely clear, no further recommendation is made. As on the next, the matter will be hard on merit. Already.
I'm filing a rejoinder in item 7.
Continue file it. These are the registry.
My lord, may I give other numbers of the today's list? Item 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 104, 107, 108, 111, 112, 114, 115, 118, 119, 120, 121, 122, 123.
In fact, most of the cases I am appearing, I have given that list also.
I'll give them.
Mr. Muduli, you just give the numbers.
I'm giving.
Yes.
All the matters in view of the order passed in the first cycle. Then the matter will be listed.
Another problem.
Item is this.
The lead case.
What is this?
79th or 79th.
That is what. In Niranjan the Behera's case, you are appearing.
Yes. Item 10.
I am appearing. What I suggest 79, where counter rejoinder been filed, and if my one friends would all agree, that will be the lead case.
Yes.
Counter rejoinder.
All matters will be tagged along with that 79, my lord.
Yes.
Some left out matter that has not come to today's list.
In the list.
He is giving so only night you can accept that.
Matter will listed. State has filed a No, before, yeah, the 14th of September. Yes. 14th. And any additional work is required. September 2023. It is made absolutely clear, no further recommendation will be made. It's all right. Last name should be here.
I only request they may serve a copy of the reason that input.
That is obvious. This is the rule.
I understand that it should be done. The next one finally.
Item number 9. 9. Yes, madam. Item number 9. I have to file counter affidavit. I seek 3 weeks time.
Okay, that's the matter with this.
On that same 21st September, your lordship.
21st September 2023, at the request of Mr. D.K. Mohanty, Learned Additional Government Advocate. Meanwhile, the opposite parties shall file their
I will file the counter in the meantime.
So no further recommendation will be made. You are appearing there?
Petitioner.
What is your good name?
Mr. Birja Prashan Das.
No. What is your
name?
Shelly Das. Shelly Das.
MS Das Current Council appears for the petition. All right. Next.
Item number 18. Same matter, excise matter, same date. For filing of counter, your lordship has directed.
You are also there?
Yes, he is also.
Same order prepared.
Item number 19. My lord, in item 19, your lordship has directed that
Yes. In this matter, my lordship is directed to take instruction so far as the order of closure is concerned, my lords.
in this case, a particular person was running a brick kiln without the permission of the pollution control board. And your lordship took cognizance of that, and that order was communicated. The Tahsildar has in the meantime undertook a raid, and penalty was imposed. Everything I have given the report of the Tahsildar.
Penalty was imposed by the Tahsildar?
Yes, ma'am.
He has the authority to impose the penalty.
When
do the Tahsildar has the authority to impose the penalty?
All district administration.
How they wonder what law?
Because he was under the OMNC rules, because they have to take permission from the Tahsildar to for this brick. So as pollution matter, that permission is concerned, that is taken care of by the SPCB. But for construction of that chimney bhatti and to undertake the work, they have to take the permission of the Tahsildar. And we have sealed the premises also, which was running without the permission of the pollution control board.
Okay. But I don't think
I am serving a copy to my learned friend that the report of the Tahsildar. So lordship may fix it to some other date.
The report of the Tahsildar is there. This is the letter. That is to your office.
That I have obtained the report. I am just submitting it in shape of affidavit. Also, I can file.
All right. For how many days did you have been? Operation has been stopped.
Yes, my lords. My lords, that instruction I have to take so far as the report of the Tahsildar is concerned. My lords, I have to take instruction from the petition.
Let him file it.
Yes,
Yeah,
yes.
I am giving a proposal.
Madam, I am on behalf of I am also appearing on behalf of the two parties. There is the operation has been totally stopped. The Tahsildar is taking every year fine. There is no operation at present.
Okay.
I shall also, the copy may be solved, I shall also file a written.
I'll serve a copy.
But where is the order stopping operation?
My lord,
Answer it passed by the State Pollution Control Board.
after the national
Closure order stopped it since long, but this was not executed. Operating.
after the national green terminus order passed in the year of 2016, my lord.
Oh, that is in terms of that order.
Yes,
You inquire. All right. So how many petitioners are there?
Well, let's see. 5 petitioners.
5 petitioners.
In one case,
And the second case,
8 petitioners.
Mr. Prabhu Prashanna Mehra, counsel appears for the petitioners. So it appears that maybe state opposite parties have not filed any counter affidavit just yet. Let them file the counter affidavit by the next date. Till the matter on 14th September 2023. It is needless to mention that before filing the counter affidavit, a copy thereof be served on the counsel for the petitioner and the other opposite parties. You are appearing for 2 and 3.
No, my lord, that's number, participant number 8.
He's the private opposite party.
Private opposition.
Private means who was operating unauthorized.
Yes.
You are appearing for the first time today?
Yes, mine.
There is a problem here. You will file the Vogalatna.
No, my lord, I shall drop there. There is no problem.
Okay, what is your good name, sir?
Gopal Prasad Jana.
Mr. GP General and Counsel has appeared for the first case. You are there.
In the Rajendra Bari for 2-5, yes.
8.
Yes, my lord. Akshay Kumar Sethi.
This case, there is no party like Akshay Kumar Sethi.
Petitioner is Akshay Kumar Sethi. And he is appearing for opposite one or 8, I think.
Yes.
From 8 type of?
Yes. Yes.
Mr. You are appearing not for all the petitioners?
Yes, madam, all the petitioners.
How can you appeal for the petitioners?
My lord, opposite number 8.
8?
Yes.
Opposite party number 8 is a partnership form, the DKB Bricks.
Yes, my lord.
Operating there.
Okay, if it's for the opposite party number 8. Mr. Mahathir Council has submitted that the Tahsildar, after inspecting the unit of the opposite party number 8, has sealed the unit. And also
imposed penalty fines.
We said all of the Tahsildar be placed with the counter affidavit.
Yes.
Yes. Then the next matter.
20.
Next matter also you are appealing for.
Same.
Just check out with the party D. Justice name will be there. So all the same way.
This one, proceeding is not mentioned. It is only stated.
No, the same matter don't mention the last 2 lines. The process that is sealed, that lines should not be there. Okay?
To impose royalty and.
Item number 20 is 21st September.
14th September.
14th. Okay.
Second item you check because order of sealing that is not mentioned in the instructions.
I will check. I will file in separate affidavit.
Who is appearing for the petitioner in this matter? First of December. Yes.
Item 21.
Yes.
To the last matter. Mr. Appeal is conviction, my lord. That appeal is convicted but 3 years and life matter for life.
Yes.
Petitioner 2, 3, 4, and 5 are the direct witness who are alleged to have seen the occurrence, my lord. But their evidence is contradictory to each other, my lord. I am placing the deposition of PW2, my lord.
Okay.
The Krishna.
So according to you, PW2, PW4,
2, 3, 4, 5, 6 are the immediate neighbors.
no, who is the, according to the prosecution, the eyewitness?
2,
Please
3,
order the
And
4,
5.
5.
So not 6.
6 is the inquest evidence, my lord.
All right.
7 is the doctor and the 9 is the IO, my lord.
What is the date of the order?
21/6, 2023. This was the hearing did not want to.
Have you got the instruction? Please appear in Mr. Katakia.
Yes.
What is the, this 21/6, there was an instruction, you are asked to take an instruction. For how long this appellant is in custody? Have you brought it?
Yes, I'm just finding to.
All right.
First set would have obtained below, that is on record.
Ah, that is what I'm checking now. It is there.
Yes. Very flag game also.
It is about 14 years, 15 years in custody. All right. What is your basic ground in this appeal?
Basically,
that these witnesses cannot be believed by the court.
Yes, ma'am.
Because they have destroyed each other's case.
Yes,
This is the
ma'am.
sole
Yes,
ground.
yes.
Okay, read then this 2, 3, 4, and 5.
My lord. First time reading, my lord, deposition of PW2. I know the accused. I got it, my lord. This is Krishna Minyaka.
Yes.
I know the deceased Samba who was married to the accused. My house is situated 2 houses apart from the house of the accused. About 8 months back, one day at 7 a.m., the accused assaulted to the deceased by means of an iron rod in the backyard. He inflicted X blow on the head of the deceased, causing bleeding injury. I saw the said incidents while standing on my backyard.
Okay.
I ran to the spot to save the deceased. At the spot, the deceased with bleeding injuries was lying. Out of fear, I came away. When the accused left the spot, I again went to there and touching the deceased, I found that she was already dead. I gave information about the said incidents to PW1. Police investigation, my statement was recorded. During investigation, my statement was recorded. That the IO made inquest over the dead body and prepared inquest report in my presence. The IO seized in my presence the blood stained earth and sample earth and prepared seizure list. The IO also seized an axe and iron rod from the house of the accused on his production and prepared seizure list matter. That to cross examination. Our backyard is adjacent to the back.
Produce this axe, the accused.
Yes, my lord, the doctor is saying that was not produced before him.
No, it's all right. That is a separate part.
Yes.
But the scissor was made when it was produced by the accused.
Accused, my lord.
So accused was arrested and in custody. He made some statement under section 37 of the Evidence Act.
That is not there, my lord.
All right, we'll find out. Okay. It will only be available from the investigating officer's statement.
Yes, yes. He is saying 1 blow by iron rod and 1 blow by X.
Okay.
The PW3, my lord. One Minyaka Kosturu Minyaka. I know the deceased was married wife of the accused. She was staying with the accused in his house.
My house is situated close to the backyard of the house of the accused. About 9 months back in one morning at about 7 a.m., the accused inflicted 2 X blows by the sharp side of X on the head of the deceased in the backward. As a result of which, she sustained bleeding injury and fell down and died. I saw the aforesaid occurrence from my house. After
So he is also corroborating that the blow was given.
by means of X and 2 X at blows.
According to you, there is a 2 injuries, but the sharp side to those who are given. All right.
But the medical opinion suggests there are different injuries, my lord.
All right, come to the medical list. Then go to the next 4.
4, my lord. Mattia Minyaka. About 8 months back in the morning at 7 a.m., the accused first assaulted on the side of chest of the deceased by means of iron rod, and again he dealt X blow on her head, causing bleeding injury and death. I saw the said incidents from my house, which at a distance of 30 feet. Since the accused threatened us to kill, we out of fear remained outside the house. When the police came to the house, we came to the outside.
Yes. Then 5.
5, my lord. This is Minyaka Kunti. The deceased and her brother, who is the informant, and the deceased are known to me. My house is situated at a distance of 40 feet from the house of the accused. About 8 months back at 7 a.m., the accused committed murder of the deceased by assaulting on her left side chest by means of an iron rod, inflicting a blow by the sharp side of X on her head in Bari. With the X blow, the deceased died at the spot. The body of the accused in which the occurrence took place had no fence standing on the passage near the body. On 19/3/2009, I was in the same post of Raigada District Headquarters Hospital. On that day at 5 p.m. to 6 p.m. on police requisition, I myself and Dr. Bharadakanta conducted postmortem examination over the dead body of Srimati Minyaka. Found the following is on external appearance, we saw an incised wound 10 cm into 3 cm 2 cm present over the outer side of right upper arm, 15 cm below the right shoulder. Second, incised wound of size 5 cm 2 cm bone dip over the left parental area of scalp with fracture of scalp bone to the wound. Bruise over anterior aspect of left chest. Its size was 10 cm 3 cm, situated 15 cm below the left nipple. Thereafter, bruise mark present on the backside extending from the left shoulder to right shoulder. Its size was 20 cm into 3 cm. On dissection of the dead body, we noted that membranes of the brain corresponding to the parental bone fracture were torn with the presence of subdural and hemorrhage. Lacerated injury to the brain matter was also present along with bleeding to the surrounding brain opposite to the left parental bone fracture. We also noticed fracture of 7th, 8th, 9th ribs left side along with the anterior axial line. The cause of death was due to fracture causing injury to the brain leading to shock and death. The time of death was within 24 hours from the time of her postmortem examination. This is her postmortem exhibit for original signature. All injuries which are noticed were antemortem in nature. The brain injury was sufficient to cause death. Incised wounds found on the brain and right shoulder were possible by a sharp weapon, such as sharp side of an axe. Bruises, abrasion were possible by hard and blunt weapon. Fracture 7, 8, 9 ribs was possible by hard and blunt weapon like iron rod. In cross-examination, no weapon was produced before me by the IO. The dead body was not decomposed by the time of our examination. The 8 is the sky of the affair matter.
Sorry, you are not questioning that, I think. Come to the investigating officer statement.
9, PW9.
PW9, yes.
During investigation, I examined the complainant and sent a requisition to the SDM Raigada for deployment of executive magistrate for purpose of inquest. I visited the spot and prepared spot map. I personally took photos of the deceased in different processes. I also seized blood stain and sample earth from the spot and prepared seizure list. I held inquest over the dead body in presence of the magistrate and prepared inquest report by the Exhibit 1. Sent to the dead body to Raigada Hospital for postmortem examination. I arrested the accused and seized the weapons of offense such as axe and iron rod having sharpness at one end from the possession of the accused and prepared seizure list. I issued a letter query to the doctor and discussed with him. The doctor opined the injuries of the deceased which he saw were possibly by seized weapons. Seized blood stain, seized blood stain and sample earth and nail clippings of the accused were sent to RFSL Barampur for chemical examination. On completion of investigation, I submitted charge sheet against the accused. I gave nose flowers of the deceased to the informant on Jimanani and obtained Jimana from him. Exhibit 6 is my letter to the medical officer for collection of nail clippings, and Exhibit 6/1 is my signature. That was in the cross-examination. I have not prepared any seizure list regarding seizure of nail clippings or command certificate. I have no seized wearing apparels of the accused. Villagers were not present at the spot when I reached there, but on seeing my arrival, some people of village came there. I have not seized the deployment order of the SI. The executive magistrate reached the spot at 2:30 p.m. After arrival, I made inquest of the dead body and thereafter seized the weapon of offense. The accused was in the outside of the village, that is within 500 meters from the village. I didn't see any abnormality behavior of the accused. My investigation reveals that the accused first assaulted to the deceased by means of iron rod and thereafter inflicted X blow on her. The death occurred due to X blow, but I didn't make any query to the doctor in that respect. It is not a fact that there was no such injury and that my investigation falls under. Charges were from 498, 506, 11 and they acquitted from the 498 and 506. Because
only on 302.
Yes.
Simplicity. Where is the contradictions? Major contradictions. First of all, see the doctor's report.
Yes.
He talks about the 4 injuries.
Yes.
2 are lacerated injuries. They are caused, means when the X is taken out, that injury can be caused. So 2 major injuries. One witness says give the blows.
Yes.
One with the rod, and only a problem is with the PW2.
Yes.
He says the 1 blow given, he went there. He was also looking how many, because someone is in a distance of 30 to 50 feet away. And in a fraction of a second, what happens may not grip. But the physical injuries and the other witness's statement are in corroboration. One is stated, even if his statement is incorrect, that cannot be basis of reversing the judgment of conviction.
PW2 is the person who informed PW1.
All right. And also PW2 has given a clarification subsequently, paragraph 4.
The accused dealt only 1 stroke by means of an...
No, the IO made inquest over the dead body, surgeons, and prepared the seizure list. Surgeons.
Yes, the accused dealt only 1 stroke by means of an iron rod on a side of belly under the left chest of the deceased. Yes. With a said stroke, the deceased bent her body. The accused also dealt only 1 blow with the sharp side of metal object.
No, just you read it. I know the accused, I know the deceased Samba, who was married to the accused.
Yes, my house is situated
2 houses apart, that is about 40 to 50 feet away. Surgeon says, the accused assaulted to the deceased by means of an iron rod in his backyard. He inflicted X blow on the head of the deceased. So he is also categorically talking about the 2 blows.
Yes.
One is a completely blunt weapon. The doctor's first injury is a blunt weapon, and the second is by the X blow, the sharp cutting weapon. So he is not stating anything in contradiction or in contradicting the other witnesses. He has made it 2 separate parts. That cannot be actually demolish the prosecution evidence. Sorry, learned counsel coming in better case. Heard Mr.
I'm SN Mr. Foreman.
Mr. S.N. Misra, learned counsel appealing to the appellant. Also heard Mr. J. Kotokia, learned additional government advocate appearing for the state. By means of these appeal, the sole appellant has challenged the judgment and order of conviction and sentence dated 22nd January 2010 by the additional session judge Raigada in criminal trial number 60/2009. Stop. By the said judgment, the appellant was convicted under section 302 and he was inflicted with the consequential sentence of rigorous imprisonment for life with fine of rupees
10,000.
With fine of rupees 10,000 with default imprisonment of 4 months. Stop. By the said judgment, the learned additional session judge, hereinafter referred to as the trial judge, has clearly observed that the appellant caused the death of the deceased namely
Maniaka Samba.
Namely Samba. What is the name?
Maniaka Samba.
Maniaka Samba. His wife. By giving blows by iron rod and axe on the chest and the head. The postmortem examination report has clearly stated that that because of those injuries, the deceased died. The trial judge has believed the evidence of PWs 2, 3, 4, 5 and PW 9 so the said judgment of conviction is under challenge in this appeal. Prosecution case, briefly stated, the prosecution case is that on 19/9/2009, one recall base of village Kedapadu filed a written complaint at about 11:30 a.m. to the IIC, to the Raigora police station, disclosing that Miniaka Samba has been assaulted by the appellant on 19/9/2009 at 7:30 a.m. Based on the said information, Raigora PS case number 66 of 2009 was registered. It is 9 or 2000? It is 2000. 2009. Just check up it. 2009 was registered under section 498A/
302 and 304B.
506 was also there? No.
Not in the FIR matter.
302 and 304B of the IPC. So, on completion of the investigation, the charge sheet was filed against the appellant in the court of the subdivision of Judicial Magistrate Raigora, who, after taking the cognizance of the offences, under section, what is the chart orders? Offences under section
498A, 302 and 506.
498A, 506, 302 of the IPC. Committed the case for trial to the court of the session judge. So in the course of time, the trial was transferred to the court of the additional session judge, Raigora. Stop. The charge was framed under section 498A, 302 and 506 of the IPC. Stop. In order to substantiate the said charge, prosecution adduce as many as 9 witnesses, including PWs 2, 3, 4, and 5, who claim to be the eyewitness of the occurrence. The prosecution has also adduced the postmortem doctor within bracket PW7 and the investigating officer PW9 that apart the prosecution introduced as many as 12 documentary evidence, including the inquest report in bracket Exhibit 1 and the post-mortem examination report Exhibit 4 and the FIR Exhibit 5. Stop. Mr. Misro Learned Counsel was submitted that no evidence was left for the defense, and as such, on the basis after recording the evidence of the prosecution, the appellant was examined under section 313 1 within bracket small b of the CRPC for having his response to the incriminating materials that surfaced in the evidence of the prosecution. So, allying the charges, now the appellant pleaded innocence and stated that the incriminating evidence as introduced by the prosecution is concocted. Stop. It may be noted here that the charges framed against the appellant was also similarly denied by him, raising the plea of innocence. Stop. The additional session judge, the trial judge, after appreciating the evidence, passed the said judgment of conviction. Stop. Mr. Misro Learned Counsel has submitted that on meticulous reading of the testimonies of PWs 2, 3, 4, and 5, it would be apparent that their statements are not congruous. Their statements are scattered on vital issues such as how the appellant assaulted the victim or how many injuries were inflicted on the person of the victim. But Mr. Misro Learned Counsel has fairly submitted before this court the prosecution's case is based on the testimonies of PWs 2, 3, 4, 5, and 7, as the defense did not contest the recovery of the weapon of offense from the house of the appellant. Stop. Mr. Misro has taken us to the testimonies of PWs 2, 3, 4, 5, 7, and 9 in order to nourish his submission as noted before. Stop. For purpose of appreciation of his submission, let us briefly take note of the testimonies of PWs 2, 3, 4, 5, 7, and 9. PW 9 is the investigating officer, namely Prashanto Bhupati. He has narrated briefly how he conducted the examination by collecting the materials by way of scissor and also by examining the witnesses. Stop. He has also mentioned how the dead body was sent to the hospital for postmortem examination by way of chalan and with an escort. Stop. He himself has carried out the inquest report and recorded the injuries found on the deceased person. He has also stated that he sent the blood-stained, one Tangi that within the X. The blood-stained earth, simple earth, and named clippings for chemical examination. After the chemical examination, the chemical examiner gave the report by observing that bloodstained earth marked as B and simple earth marked as C are similar with respect of their physical characterization. Over the X is concerned, the chemical examiner did not give any opinion. Therefore, we assume that the bloodstain available in the X, there was no bloodstain at all on the X, and if there was bloodstain on the X, that was not adequate enough for examination. Stop. The investigating officer, after collecting the postmortem examination report, filed the charge sheet. PW7, Dr. D. Lakshmi Narayan Pusti is the postmortem doctor who, after dissection of the dead body, observed the nature, made his observation about the injuries available on the dead body. There is a page 39 of the paper book. You find these 1, 2, 3, 4 is there. Stop. He has also stated that the peritoneal bone was fractured and inside there was subdural and subarachnoid hemorrhage. Stop. There was also lacerated injury into the brain matter. Stop. He has clearly stated that there was fracture of 7th, 8th, and 9th ribs of the left side, along with the anterior axillary line. Stop. So according to the postmortem doctor, the cause of death was due to fracture causing injuries to the brain, leading to shock and death. According to his estimate, the time of death was within 24 hours from the time when the postmortem examination was carried out. It is apparent that 2 major injuries have been referred by the postmortem doctor. One on the exterior part of the upper arm and below the shoulder, which is an incised stone measuring 10 cm into 3 cm into 2 cm. And another is the inside wound of size of 5 cm into 2 cm into bone deep left peritoneal area of scalp with fracture of skull bone opposite to the wound. Stop. These two injuries has been referred earlier as the major injuries. Stop. PW1, Vika Basu, has stated that the deceased was his sister and he was married to the appellant. Having come across the news of the death and knowing that his sister has been murdered by the appellant, he filed the first information report. Stop. He did not claim he saw any part of the transaction of crime. Therefore, even there was no serious cross-examination. PW2 is one of the PW2 Krishna Miniaka is one of the eyewitnesses, and he stated clearly that one day, 8 months before the date of deposition, at 7 a.m., the appellant assaulted the deceased by means of an iron rod in his backyard. He inflicted axe blow on the head of the deceased, causing bleeding injury. He categorically stated as follows, quote, I saw the said incidents while standing on my backward. I ran to the spot to save the deceased. At the spot, the deceased with bleeding injuries was lying. Out of fear, I came away. Stop. He was firm in the cross-examination, and defense could not make any dent to his statement. PW3, Kambali Mani Miniaka, is another eyewitness who lived in the neighborhood. She has categorically stated that at about 7 a.m., she saw the appellant inflicting 2 blows by sharp side of the axe on the head of the deceased in his backyard. As a result, the victim sustained bleeding injuries. Stop. She was also very firm during her cross-examination, and the defense failed to extract anything contrary to the examination in chief. PW4, Malia Miniaka, has also stated that he saw the occurrence leading to the death of the deceased. At about 7 a.m., the appellant first assaulted the victim on the side of chest of the deceased by means of an iron rod. And again, he gave blow by an axe over her head, causing bleeding injuries, and ultimately that injuries caused death. The defense failed to dent his statement in the cross-examination. PW5, Miniaka Kumoti, also stated in the similar manner that he saw the appellant committing murder of the deceased by assaulting on her left side chest by means of an iron rod and inflicting a blow by the sharp side of the axe on her head in his House. Succumbing to the blow given by the axe, the victim died on the spot. He was cross-examined, but the defense could not dent his statement made in the examination in chief. PW 6 is the witness to the inquest. 6 is Sheshagud Bag, is simply the witness to the inquest procedure stuff. PW 7, revolver test, is the doctor whose report, post-mortem report, has corroborated the oral testimonies of PWs 2, 3, 4, and 5. What Mr. Mesrol and counsel has submitted that there is a contradiction or incongruity in the testimonies of PWs 2, 3, 4, and 5 is difficult to accept, as we find there is a linear corroboration of the occurrence. There is no slightest incongruity in their statements. As such, we do not find it is a case where this court will interfere with the judgment of conviction and the order of sentence in stop. In the result, this appeal stands dismissed. The appellant shall serve out the remaining period of this sentence. Stop. LCS, if still lying in the registry, shall be returned forthwith.
Obliged.
Next call, next matter.
Item number 20. Yes, sir, I could not reach in time.
Place the matter day after tomorrow. If on the day there is no representation for the appellant, it will be persuaded to pass an order for non-prosecution. All right. You come prepared on inspection, we'll hear you. This is not the way.
My lord, I have no power in this case.
Today you are appearing without power. We also entertain the counsel submission on instruction. Come prepared. Otherwise, don't without brief and without anything appear before this court.
Item 20. What is your name?
Sushant Kumar.
Yes.
Item number 24.
Item 24, Your Lordship. I'm on VC. Mr. Swai is met with an accident and has undergone surgery. Therefore, he is unable to attend court. If this matter can be taken up after 2 weeks.
What is your good name? Janice Willis. At the request of Ms. Janice Willis, Learned Counsel appearing for the on instruction of Mr. Mr. Swain, Learned Counsel. Will the matter be listed on 26th of September 2023? It has been reported that Mr. Swain is unwell and is not attending the courts.
When did he suffer the accident, Ms. Wallace? I think it was 3 months back.
Yes, and because of an infection, he was unable to get his surgery done. So recently, he has had his surgery.
All right.
Obliged.
Item 25.
Item number 25.
Have you filed the application for limitation?
Yes. I have filed the application for limitation, that is IN number 5550/2023.
Where is that IU? It is not before us. Where have you filed it?
I began apology today itself. I have filed.
Then how, Learned Counsel, this will come to us?
Actually, in placing out
the day after tomorrow. List the matter day after this appeal again on day after tomorrow. The request of Mr. Ramakant Sarangi, Learned Counsel to the appellant. Mr. Sarangi has reported this court that interlocutory applications seeking condonation of delay has been filed.
I have also taken steps for removal of all the defects.
All right. He has also stated that he has taken steps for removing all the defects. So list is directed to place that interlocutory application seeking condonation of delay on the next date.
Item 26.
Yes.
I am for the opposite party, my lord. May I please? My lord.
Just wait.
Sir.
There is a delay of IA. I have filed an IA for condonation of delay. That is flag A.
Flag A, yes.
Delay of 48 days.
What is this?
Sir,
You agree to?
sir, what happened? Because pursuant to an ex parte order passed relieving me from the service, that ex parte order has been set aside by the Honorable High Court by the Honorable Single Judge. And whatever the allegation made by the opposite party that found to be.
Mr. Pandit,
Sir.
we are on limitation. Do you file the objection?
Yes, I to file the objection.
Not a mechanical manner, only 56 days delay.
My lord, it is up. My lord, can condone.
We may condone it and we take up
Yes,
in the admission.
Yes, I do oblige.
All right.
Condone it.
Take down this IA number 2401 of 2023. Heard Mr. P.K. Mudali and counsel, additional government advocate appearing for the state applicant. Is an application under section 5 in the Limitation Act for condoning the delay of 56 days, I think. 50 days. 50. 50? It is 50 days in filing the interlocutory appeal, challenging the order dated 15/2/2023 passed by the learned civil judge in WPC number 8931 of 2022. Stop. Mr. N. Pandal and counsel has appeared for the sole response opposite party. Stop. He has stated that opposite party has been suffering since long, and as such he is not opposed the prayer for condonation of delay if the matter is expeditiously hard. Stop. We have also perused the causes assigned in this application. In our considered view, the state applicants have made out a case for condoning the delay, and according to the state delay stands condoned. In the results, this application is allowed. Stop. In view of the order passed today, are you ready today?
Tomorrow.
Or day after tomorrow then? In view of the order passed today in IA number such and such.
And there is also noting that defect number 5A and 9A has not been removed. Well, in fact, today morning I have filed the legible copies of.
All right, I'm recording that. Now, W number 936. In view of the order passed in interlocutory application number such and so, this appeal is listed on day after tomorrow. One matter. Just give the time. 8.
This will come for fresh admission. Can be taken up tomorrow.
28th. 28th it will be coming. So it has been stated by Mr. Mudali Learning Council that he has removed the defect as identified by the registry. So the registry shall place a fresh report in this regard on the next date. We request Mr. Mudali Learning Council to supply a copy of the memorandum of appeal to Mr. M. Pandal Learning Council in the course of the day. There should be an attempt to hear the matter on merit at the admission stage.
I'm serving the copy.
Just give it.
Item 27.
Yeah.
Well, here at 27, I am appealing for the petitioner. Please see the last order. My lord also wants to take instruction regarding the compliance of the order.
Complaints. My lord, in the last order, your lordship has directed me to obtain certain instructions. And on the last date, the
27. Okay. Yes.
On the last date, the assistant executive engineer himself was present. I called him because your lordship wanted to know certain facts. But today he is unable to come. But by letter, he has given me some instructions.
Okay. What is it?
And we will file affidavit on the next date. If your lordship will say, I will read the instructions which I have received. Or we will file the whatever he has given. I in shape of affidavit. I will give.
List the matter on 4th.
Well, matter will be taken up on 4th.
14th of September.
14th September.
So, in the meanwhile, the opposite parties may file their counter affidavit if any. Mr. N. Pandal and counsel has secured for the appellant and Mr. Dr. Mahathir and Vijay Government for the opposite parties. Already filed it 14th.
But before that date, I will file in September.
Already filed it.
Item number 28.
Yes.
My lord, in this case, the notice has been issued, but in the compare.
I'm appearing in VC, my lord.
Yes.
But day before yesterday, I received the notice information to appear in this case. Due to I was residing at I was in Bhadra court, for which I am not appearing in physically before lordship, for which I am a pardon. But the writ of filed by the state is suppressing some material facts, ma'am. They have not filed the proper order of the video. That they have made a approach before the chairman of the Jilla Parishad to modify the houses benefit which was given by the other persons for approval in the name of the petition, my lord.
Who is appearing for the sole respondent? Notice has been issued.
I think he is appearing for.
You are appearing. Have you filed the Vakalatnama?
Today morning, I received the brief and instruction from my client.
My lord, may I suggest one thing, your lordship? There are two cases, two writ appeals, 1071, 1072. I think my learned friend will also appear for the respondent in Jan 1072. Your lordship.
1070.
70, I'm sorry, 7071. So both the cases may be fixed for hearing on some other date, and in the meanwhile, let him, if he wants, let him file any affidavit or counter, whatever he wants.
Objection. Limitation application.
Limitation is there, correct, sir.
Yes.
Yes, limitation. It may be tagged with 1070. That will be more convenient. Same order, same.
It is on board today 1070.
No, my lord.
Always.
Yes, my lord.
Is it board?
Item 73, perhaps.
Today in board.
Item 70.
Oh, I'm sorry, my lord. I'm sorry.
Mr. B.S. Mishra. You are Mr. B.S. Mishra. Huh?
B.S. Mishra.
What is They removed the mute. Yes, Mr. Mishra, you are. Yes,
Mr. Mishra, we can't hear you. Just check if your mic is on.
Check the.
Yes, my lord,
Yes.
Right now it's okay. You are Mr. B.S. Mishra. Are you appearing also in the 1070?
Yes, your lord.
All right. We are fixing the matter some other day. And in the meanwhile, you file your power and everything, and also any other steps.
Objection, if any, to the
objection, there is a limitation application. We file it. Any request of Mr. B.S. Mistral and the council appearing for the sole opposite party. This is in I number 27. I number 2771 of 2023 has appeared for the sole respondents to the virtual High Court from Bhadrak. Mr. Mistral and council has submitted that we will file the Vakalatnama within a short while. So, let the matter be listed on 27 September 2023. Meanwhile, the opposite party may file the objection if any. Mr. D.K. Mohantil and council is appeared for the
interim order to continue.
Interim order is passed earlier, shall continue till the next stage.
My lord, 73 item is same order.
There is also limitation application.
Yes, madam.
Just 73. Yes. Again, your voice is not audible.
What's your date?
Date is 27th September.
Because, my lord, it is a long time because the petitioner are the poor person residing now.
No, long time it is all right. Long time it is all right. Court has also his cause list is there. Court has to list the matter according to the time schedule. Okay.
My lord, in the year 2017, they have no roof over his head. There are no roof, my lord. They have already lost their houses by the way of lighting, my lord.
That's all right. We'll decide it on that day. You come prepared. On that day, we'll decide it.
I pray for a short date, my lord.
And listed matter, first matter, along with that 1070?
73. Item number 73.
All right.
Item 29.
My lord.
Yes.
29, my lord, I think should be registered as CRLMC. The prayer is not to arrest. CRLMP. Voting says.
My lord, it is wrongly mentioned as the
CRLMP.
But I have filed the CRLM, the WPC criminal, so that I will correct that petition.
Where it has been mentioned as CRLMP, it should be CRLMP.
Yes. Because the prayer is that the OP number 3 may be directed not to arrest him.
Okay.
That false FIR has given in the name of my petitioner, in my petitioner, false FIR, where the petitioners are the government employee.
How can such prayer you can make? Huh? The other means. Yes.
Item number 30.
Item number 30, my lord. This matter relates to Shishu Bhavan, my lord. This matter appears today as per order number 44, dated 7 August 2023.
Yes.
The relevant paragraph of the said order is at para 3, my lord. If your lordship permits, then I will place the para 3, my lord. We are unhappy in the manner the personal affidavit has been filed by the Commissioner cum Secretary, Health and Family Welfare Department, Government of Odisha, as most of the statement do not contain any specific assurance of implementation. We make it absolutely clear that the date of implementation shall be made specific. For that purpose, a fresh personal affidavit shall be filed by the Commissioner cum Secretary.
What is there? Why you are reading it? I am just a minute. What I am placing. Your lordship may see on 18th August, I have filed an IA number 12846 of 2023.
Yes.
In that IA, the government has asked for 10 days time to file the personal affidavit in compliance of that order.
We have no objection, my lord.
That's all. Then
let them file their application, but that will be the last chance, my lord.
No. You cannot compel like your lordship. Let me tell you, submit your lordship. This is not adversary litigation. They are fighting the case as if we are their opposite parties. We are there.
No. Their pain is that you are not responding as.
We are responding.
My lord.
Yes. All right. I have the request to Mr. DK. What is this IA number?
IA number with 12846 of 23. 12846 of 23.
So it is not before us. All right, generally granting time. The IA is not before us.
IA we have filed in
on Friday.
Friday, yes, on Friday.
Thereafter, 2 intervening holidays were there.
I am very sorry, my lord. I am extremely sorry. But this is the number. I have soft copy on them.
Yeah,
just now we have to give it.
Why don't you give me a copy?
We have received a copy today. Just now.
What is the IA number?
12846 of 2023.
Mr. DK Mohantil and Additional Government Advocate urge this court for granting an
2 weeks time I have prayed
Granting
for.
2 weeks time for filing the personal affidavit in terms of the order dated 7/8/2023. Stop. Mr. A. Mohantil and counsel appearing for the petitioner has raised no objection, but he has stated that no further accommodation should be made for the said purpose. Let the matter be listed on
8th of Friday.
Not Friday, it's not possible, on 5th of September 2023. All right,
Yes,
getting more than enough time. Stop.
The same order can be passed in all the 4 read petitions.
All right.
No, that we will file one reply in all the cases.
That is correct.
Stop. It is made absolutely clear by the said time, by the next date, such personal affidavit shall invariably filed. This court will not provide further accommodation for the same purpose. Stop. Other your names will
The copy will kindly serve in advance, not in date. The copy will kindly serve in advance. So maybe
served in advance. This is my
serve the copy of the affidavit also in advance.
Yes.
I have got one small submission to made in this case, my lord. During the bench, we have filed an additional affidavit in this case, my lord. Just to reply to that also. That is at flat 70, my lord, of your lordship brief.
We will give reply in terms of the omnibus order.
This is that additional
I
affidavit.
think you should place this additional affidavit on the next date.
Next,
Let us
that
see
is not
what the
accepted.
personal affidavit.
My lord, obliged.
All right.
That is not accepted.
Oh, it's already after lunch. The rest of the matters will be taken up after lunch.
Obliged.
He is there.
Yes. Even office also.
Oh, office is also sent. So that the original copy from the office has now been received by us. It is 70.
133, my lord. Yes, I am the appearance. We already prematurely released, my lord.
Yes, yes. You are Mr. Patnaik.
Myself, H.K. Harikrishna Malik.
You are not on record.
Legal aid counsel.
Oh, Mr. H.K. Malik, Legal Aid Council, has stated that the appellant has been released prematurely from the circle jail on 3/9/2021 by the order number 8662/L dated 27/8/2021. Mr. J. Katuki, learned additional government advocate appearing to the state, has also confirmed the said fact. That apart, Senior Superintendent Circle Jail Cutoff has communicated the registry of this court by his communication dated 27/2022 that the appellant has already been released, has been released on 3/9/2021. The communication and received by the registry is taken on record. The second copy. So, in view of the above development, this appeal has become infructuous. Accordingly, same is dismissed as infractions. Any records lying in the registry received from the trial court, please send forthwith. Please send down forthwith. Okay.
Matter fixed for 2 p.m. hearing, item number 68.
Yes.
Minutes assistants have prepared a sequence of the proceedings that has taken place in the present dispute.
Yes. You show us the decision of 18 September 2006 of the authority in terms of the order of this court in WPC number 151046 of 2005.
Manoj should come at page 23 of the appeal memo.
It is 69.
68.
That page?
It's page 23 of the appeal memo at annexure 2.
Yes.
Well, it's subsequent to the first writ application preferred by the appellant, wherein the direction was given to the sub-collector to dispose of the allegation of the appellant, my lords. 23 is the relevant order that my lords asked for, which has been rejected and the appellant has been unsuccessful. It's challenge. The relevant part is, my lords, at page 25.
Yes.
It's after being unsuccessful under annexure 2.
Yes.
The next page, Manoj, at page 26. the petitioner moved this honorable court for the second time. The appellant moved this honorable court for the second time, challenging the legality of Annexure 2.
Yes.
My lords, the findings of this honorable court is at page 27, starting from paragraph 3. Mr. Collector, my lords found it. It's the collector, however, relying upon the residential certificate issued by the Tahsildar and other materials, arrived at a conclusion that opposite party number 4 is residing in the village where the Anganwadi center is situated. The petitioner asserts the said findings as erroneous. But then, the residential certificate issued by the Tahsildar under the miscellaneous certificate rules, certifying that opposite party number 4 is the resident of village Dudki Dadar. Law is well settled that a residential certificate issued under the rules is binding upon all concerned till the same is cancelled. Admittedly, the petitioner has not taken any steps till today to cancel the residential certificate issued in favor of the opposite party number 4. In the absence of such attempt, it shall be presumed that the opposite party number 4 is the resident of the village mentioned in the residential certificate. In view of the opposite discussion, after going through the pleadings and documents, this court is not inclined to interfere with the impugned order. However, liberty is granted to the petitioner to work out a remedy in accordance with law.
All right.
Pursuant to this, my lords, the appellant initiated the proceeding to cancel the residential certificate of the respondent number 4.
After or before this order?
My lords, pursuant to this order, after this order, my lords.
Not pursuant to this order, because this order is not directing you to pursue.
No,
now, because understanding your flaw, you have proceeded for the separate proceeding. What is the result of this appeal?
My lords, Annexure 5 is the minutes of the proceeding initiated by the appellant to cancel the residential certificate after my lords Annexure 3, which my lords just produced. This Annexure 5 starts at page 32.
Yes.
My lords, the findings of the lower appellate authority starts from page 36. My lords found page 36. My lords, in the middle of the page, the heading says findings. From point number 6 starts the findings as to how the respondent number 4 is not a resident of the concerned village. It is a fact, Dhanmati Naik, my lords, who is the respondent number 4, is married to Khirasagar Naik of village Bhaisadhara on 4/3/2001. It is a fact that Khirasagar Naik is a resident of village Bhaisadhara. It is a fact the name of Dhanmati Naik is mentioned in the voter list of 2004, 5, 6, 8 and 2007. It is a fact that the name of Khirasagar Naik, husband of Dhanmati Naik, is mentioned in the voter list bearing in 2001, 4, 2005, 2006, 2007, 2008. My lords, on the next page, at page 37, it is a fact that CDPO Jharkhand has supplied information under the RT Act to Akshay Kumbhara with a letter number so-and-so regarding birth, immunization and survey report of family members of Khirasagar Naik of village Bhaisadhara. Point number 11, it is a fact that medical officer CHC Dawa has supplied information under RT Act with his letter number so-and-so to Akshay Kumbhara regarding birth and survey report of Dhanmati Naik, wife of Khirasagar Naik of village Bhaisadhara from the year 2001 to 2005. It is a fact that RTI Jharkhand has not properly inquired with regard to the residence certificate of Dhanmati Naik. Once point number 12 refers to the earlier inquiry report, basing on which residential certificate was issued in favor of the respondent number 4. Then there's the order. Well, on the second paragraph of the order is the operating portion. The order passed on 6/5/2005 by the learned additional Tahsildar Paikomara in this case number 270 of 2005 is set aside, and remanded the LCR to the court of Tahsildar Taikamala and directed to conduct inquiry afresh and hear both parties and dispose of the miscase within a period of 3 months. That's consequent to this finding.
Yes.
Well, it's the Tahsildar on 6/4/2015. But this is 13th of January 2015. On 6th of April 2015, the residential certificate issued in favor of the respondent number 4 was cancelled by the learned Tahsildar, and she was asked to surrender the same before the authority.
Okay.
Well, it's now that the residential certificate was cancelled in favor of the respondent number 4, as per the appellant, my lords, she stopped being eligible to continue as Anganwadi worker. However, by that point of time, she was still continuing. The appellant preferred another writ application before this honorable court, which my lords would find at annexure 7, page 40. Second writ application was preferred, challenging the findings of the cancellation of residence certificate. The respondent number 4 also moved this honorable court at annexure number 6 on the ground that the challenge by the appellant to initiate the proceeding to cancel her residential certificate is barred by limitation. My lords, at annexure 6, page 38, this honorable court, in the writ application preferred by the respondent number 4, remanded back the matter again to the sub-collector for rehearing on the question of limitation. This is one aspect. The second aspect is that in the writ application preferred by the appellant, wherein the respondent number 4 was still continuing as Anganwadi worker despite her residential certificate being cancelled, this honorable court directed competent authority to issue fresh appointment orders in favor of the appellant. That appointment order was issued by the competent authority on 26th of June 2019, wherefrom till date the appellant is working as Anganwadi worker in this concerned center. When this honorable court remanded back the matter for hearing it afresh, both parties were given extensive opportunities and the appellant was made to justify her delay in initially instituting the case for cancellation of residence certificate. My lords would find the subsequent proceedings order at annexure 9, page 47.
Okay.
My lords, at annexure 9, considering all the documents submitted by the petition by the present appellant, including relevant judgments, the learned sub-collector at page 52 gave its finding. My lords, at page 52, the order says, in view of the above analysis and interpretation, I am inclined to pass order that this court has not committed any mistake while passing the order of condoning delay in filing the appeal. Hence, the final order dated 13th of January 2015 is upheld.
What is the authority of the appellate authority to condone the delay? Is there any specific statutory provision?
My lords, in the provision, the statute says any unsuccessful or someone aggrieved by residential certificate can file an appeal within a period of 3 months.
3 months. If not filed within 3 months?
Well, it's proviso say, well, it's if I can read that.
Just you read that because I have come across that proviso, right?
Well, it's it's Odisha Miscellaneous Certificate Rules 1984 minutes. I'm reading the particular proviso minutes. Rule 8 proviso of Odisha's Miscellaneous Certificate Rules 1984.
Yes.
Provided that no appeal under these rules shall be entertained unless it is preferred within a period of 3 months from the date of the said order.
Yes.
After the second order is confirmed, the following development took place. As such, the appellant was continuing to be the worker of Anganwadi Center.
Yes.
My lords, challenging the second order, the respond number 4 preferred writ application, which is impugned before my lords right now. WBC 7035 of 2018. She preferred another proceeding in the shape of a writ appeal, challenging the order of this honorable court, wherein direction was given to the authorities to give an appointment to the present appellant. 2 proceedings were initiated by the respondent number 4 before this honorable court. First was, my lords, the writ appeal challenging the direction to the authorities to issue appointment to the appellant. Second, my lords, is the present writ application, which is impugned before my lords, wherein for the second time the order cancelling the residence certificate has been upheld. My lords, in the writ appeal, this honorable court was pleased to dismiss, holding that there is no infirmity in the order passed by the honorable single judge. My lords would find the order of the writ appeal at page 53.
Yes.
And my lords, the operating portion is at page 58. That is Annexure 10 to the appeal memorandum. My lords, the operating portion reads as, from para 3, no order of stay has been granted. So, at present, as the matter stands, there is no certificate in favor of the appellant showing her to be the resident of Dudki Dadar, and we come to the conclusion that the order passed by the learned single judge is correct and has been delivered in its proper perspective, which requires no interference. My lords, thereafter is the impugned order. My lords, yes. The humble submission of the appellant is that the appellant presently concedes that even though she had filed her power, but at the date of hearing, my lords, she was not represented. She was not, that my lords, the appellant concedes. My lords, apart from that, my lords, her humble submission is that during the hearing of Annexure 1 of the impugned order, the factum of previous 2 writ applications, wherein the order of the residence certificate has been upheld, she was given an appointment, and subsequent dismissal of the writ appeal were not brought. The appellant humbly submits that with the order of passing in the writ appeal, the question whether the legality and propriety of the order passed by the learned sub-collector as to whether the cancellation of the residence certificate could have been opened, the appellant humbly submits that now that the issue has attained finality with the passing of the order of the Honorable Division Bench, in the subsequent writ application impugned before my lords, had this factum been brought to the notice of this Honorable Court, the impugned order in humble submission of the appellant could not have been passed. My lords, the impugned order at page 60. My lords, the relevant part is at page 63.
Yes.
My lords, para number 4, record shows learned advocate had entered appearance on behalf of private opposite party number 5, my lords, who is the appellant before my lords, who today goes unrepresented. Submissions made by Mr. Rath are accepted. Aggrieved person referred to in Rule 8 can only be an unsuccessful applicant under Rule 6. In such view of things, it is not necessary to adjudicate a limitation. Also argued by Mr. Rath, impugned order set aside and quashed, concerned authority is left to act in accordance with law. Plus, challenging this, the applicant is before my lords. Once applicant's humble submission is that, well, the discussion by the Honorable Single Judge is in the teeth of Annexure 7 and Annexure 10. Once Annexure 7 is the order in which the Honorable Single Judge has upheld the previous proceeding and given an appointment, taking into the fact that the residential certificate has been cancelled. Annexure 10 is the writ appeal challenging the said order by the respondent number 4, which has been dismissed. But the humble submission of the appellant is that in presence of Annexure 7 and Annexure 10, the order which my lords just sought, Annexure 11, could not have been passed and is in the teeth of Annexure 10 and Annexure 7. Although the appellant again reiterates that she concedes that she was not represented, but had this factor and my lords, in the cost title of 7035 writ application, which has been attached to my lord's brief right now, in the reference cost title, so there is no reference to these previous writ applications that were being contested by both parties. And appellants submit that all those writ applications were very much necessary while deciding Annexure 7. Sorry, my lords, Annexure 11. In the reference cost title, only the writ application that was preferred by the respondent number 4 has been mentioned.
So finally, your argument is that since in view of this writ appellate order, that a single judge would not have or should not have passed that order that you have challenged, which is under Annexure 11.
My lords.
That's all.
My lords.
Who is appearing? Anybody is appearing for you are appearing for my lord. How that a single judge can.
I will kindly see the order passed in the writ appeal, my lord.
This Annexure 9.
Annexure 9, my lord.
No, sorry, Annexure 10. Annexure 10.
Annexure 10. Kindly see the page 58, paragraph 3. In the writ appeal, and then that note I have filed, my lord. The writ appeal, in the writ appeal, my lord, the order of honorable single judge was challenged, where I was disengaged and an engagement order was in favor of the appellant was issued, my lord. Paragraph 3, my lord. Additionally, it is seen that there is no dispute that the last date of filing of applicant in pursuance of the notification that so-and-so was so-and-so dated 15/2/2005. Annexure 2, the residence certificate was issued on 6/5/2005 and the document has been cancelled. First, we could not understand how the application filed on order before 15/5 could be accompanied a certificate issued on 6/5/2005. Moreover, the said certificate has been cancelled in the meantime that a writ application is pending for this court challenging the order of sub-collector Padmapur. No order of stay has been granted. So at present, at the matter stands, there is no certificate in favor of the appellant showing her to be the residents of Duduragat, and we come to a conclusion that order passed by the single judge is correct and has been delivered in the proper perspective, which requires no interference. So since Honorable Division Bench in writ appeal accepted that the petition challenging the cancellation of certificate is pending before this Honorable Court, that is the order which is included in the writ appeal, Annexure page 62, which was pending before disposal of the writ appeal, challenging the cancellation of residence certificate and which was taken up on 25 January 23 and which was disposed of, my lord. So the order passed by the Honorable Division Bench in writ appeal has, with regard to the appointment for the Anganwadi selection for the post of Anganwadi. Now, with regard to the cancellation of certificate, the writ petition can see page 62. Page 62, my lord.
Yes.
But the first paragraph, here, my lord, I challenge the order of cancellation of my residence certificate, my lord.
Yes.
Which was, my lord, in para 5, my lord, the honorable single judge was pleased to quash the order of cancellation of certificate on the ground that the application which appeal, rather appeal which was filed by the present appellant, on which base the residence certificate was cancelled, he has no locus standi. My lord, kindly see last year I have shown my rule 6, my lord, of 1984. I have given a photocopy, my lord, kindly see the rule 6.
Yes.
Made. Order on the application. 1. If on the basis of the documents record and the result of the inquiry, if any revenue officer is of the view that the certificate applied for may be granted, he shall pass necessary order in the case record and sign the appropriate certificate
specifying the purpose solely on which it has been granted. The certificate shall be handed over to the applicant or his duly authorized agent on due acknowledgement of receipt. So my submission is that no outsider can receive my certificate without any proper authorization. Sub-rule 2, my lord. If the revenue officer is of view that the certificate applied for may not be granted, he shall pass necessary order in the case record, briefly recording the reason thereof. Now, my lord, can say Rule 8, appeal. Any person aggrieved by an order passed by revenue officer under Rule 6 may prefer an appeal. So Rule 6 says two things, my lord. Rule sub-rule 1 to grant certificate and sub-rule 2 rejecting an application for certificate, my lord. If any person aggrieved by Rule 6, he can only file an appeal provided that no appeal under the rule shall be entertained unless it prefer within a period of 3 months from the date of the said order. Here in this case, my lord, a person certificate which was granted on 6/5/2005, an appeal was filed in 2013 by a person who has no linkage so far the petitioner's application in receiving certificate is concerned, my lord. My respectful submission before the honorable single judge, my lord.
No, that is true, but the appellate authority passed the order correcting the record.
That is why, my lord, para 7, para 6, my lord, in the input order, para 6.
That is the way examining.
Honorable single judge has observed that since there is provision of the review is there, Rule 7.
You are referring from which paragraph of the impugned judgment?
Para 6, my lord, kindly see.
Para 6 is the impugned order is set aside and quashed.
Para 6. Impugned order set aside and quashed.
Which order?
Page 63.
Paragraph 3.
Para 6.
6 is impugned order is set aside and quashed.
Concerned authority is left to act in accordance with law. Because Rule 7, kindly see, my lord. Rule 7 says, if there is a mistake, the authority can rectify the mistake, my lord.
Yes.
So on basis of application filed by the outsider after 7 or 8 years, my application should not be cancelled. That is my only submission before the honorable single judge. That is why honorable single judge in para 6 said, or it is open to the authority. If it is any mistake is there or any error is there, they can rectify as per Rule 7.
Whether that has been done?
Because of the impugned order, no action has been taken. There is an impugned order, my lord.
What is the position in the merit list? Also between two?
Initially, only two persons were sponsored. One is respondent number 4, who was at rank 1, still number 1. The other
same
only person.
Same Anganwadi center.
Was because the basis on which the Mahila Samiti gave recommendation to respondent. I stand corrected, madam. Gave recommendation to respondent number 4 was that after marriage, the respondent number 4 and the appellant they stay together at respondent number 4's house because no one is there to take care of her old and ailing parents. That was the basis on which it was inferred that she stays in the concerned village. Only two candidates, minors. Respondent number 4 and the appellant.
I have one question. This is a broadly constitutional question. Whether these authorities are there, they are scrutinizing the fact. There comes to a finding. Whether we should judge the substituted that fact finding sitting under Article 226. Is this a proper course in law?
Judicial review is restricted.
Very, very restricted in this matter. There is a one fact finding authority, then it is going to the appellate authority pass this order. Then let us say it again interferes on the basis of reviewing the fact already asserted by these two committees. It's very difficult. What is your submission?
My short submission is Rule 7 clearly grants power to the collector to review his orders on subsequent verification or otherwise. So even if the collector receives a complaint and on verification he finds that there is some credibility in that complaint, then he can review that residential certificate.
Okay.
Your lordship knows that it is trite law that merely citing a wrong provision of law or going through the wrong provision of law does not nullify that order if the authority concerned otherwise has that power. That power exists in Rule 7. Natural justice has been complied with. Merely because Rule 8 has been cited does not nullify that order.
First of all, why you just registered it as an appeal?
It should not have been registered as an appeal. That is a wrong provision of law that's cited.
That is the problem. That is the reason why they get a boat to just spring on.
Your lordship is right. But it's made only the provision has been cited has been wrongly cited. Otherwise, the power exists.
This everywhere the power exists. We know the court has a power of review.
Your lordship.
There is also procedure laid down when the such review jurisdiction has to be exercised. Someone is aggrieved by the order passed by the sub-collector, or no, there is a Tahsildar. First authority is the Tahsildar. Then he comes to the sub-collector in the appeal. Appellate authority once decided in one way and later on decide. I would like to understand that. But whose instance, whether this matter was brought to the collector or not.
My humble submission is, once a complaint has been received, because the Rule 7 says subsequent verification or otherwise, it may have been styled as an appeal, but it is that appeal is a complaint petition. And after inquiry, if it has been revealed that yes, the certificate was wrongly issued, there exists a power to review that order.
All right. And what about the stand taken by the learned civil judge? What is the state stand about this judgment?
My lord, on the impugned order itself, that's, my lord, Rule 7 ought to have been invoked. That's my humble submission.
Rule ought to have been?
Ought to have been invoked by the collector. That's my only submission, your lord. But it does not change the fact that there is a finding that the residence certificate has been wrongly issued. And that finding of fact has been arrived at after hearing both parties.
All right.
Why not just assisting my lords? My lords, finding of fact on both occasions before the learned supplants have been the same. First it was cancelled, second it was upheld, my lords. That's my humble submission.
All right, we'll pass the order later on. Huh? Today itself we'll pass. Names of the council, huh? Right? We'll be paying for them. Just leave this, just remove the file and send it later. All right, we'll pass it. Next call.
Item 66. May I please, your lordship. I am appearing for the appellant, my lords.
Yes.
I am for the appellant. Before your lordship will go to the merit of the case, I would like to invite your lordship's kind attention to the order number 1 dated 4/4/2023, passed in this appeal. Lordship may kindly see order number 1. It is pointed out by Mr. D.K. Mahathir on counsel appearing for the appellant that although the writ petitioner had expired during the pendency of the WPC number so and so, and a substitution application to bring on record his legal representatives, LRs, was already filed and numbered as IA number so and so, the impugned order of the learned single judge does not notice the above fact and proceeds to dismiss the writ petition, noting that the shop in question, which was applied for, has been allotted already in favor of respondent number 4. It is pointed out that in respect of the said allotment, a status quo order had already been passed right in the writ petition, from the beginning. Issue notice to the respondent on the question. But as in short, I will make my submissions, my lord. This dispute relates to allotment of a shop room in a market complex which belongs to CDA, Kotak Development Authority. And The appellant before your lordship was the petitioner before the learned single judge, and the writ petition was filed. The opposite party appeared and filed.
No,
this
there is any limitation application.
Yes.
Yes, there is
Your
limitation.
lordship can have this matter of merit.
No, that first let us see where is the limitation application.
That is about my lord 3 months.
Oh, all right.
There is limitation.
So you want we allow the limitation and hear the matter on merit?
Yes. Today your lordship can, my lord.
All right. There is a delay of 115 days.
Yes.
According to the report. Just take down in the IA. P98 2023. But Mr. D.K. Mohantil and original government.
No,
private response. Yes. Sorry. Land Council appearing for the appellant/applicant, and also nobody is appearing for the Court of Development Authority. None appears for the opposite parties. The respondent opposite parties number 1 and 2. However, MS T. Mahapatra and council appears for the respondents opposite party number 3.
Respondent number 4, my lord.
4.
Who is the beneficiary?
It is 3 or 4. I'm checking up.
Four, my lord. 4.
Who is Fakir Mohan Sahu?
No.
He was the original allotee.
Original allotee.
And the land has already been allotted in favor of the respondent number 4.
They'll make it 4. Okay. None appears for the respondents opposite. No, sorry. No notice has gone, no?
No, notice has gone, my lord. It has been treated sufficient. Nobody
appears for the opposite party, the respondents opposite party number 3, despite due notice from this court.
He has refused to.
Of the delay of 115 days in filing the intercourt appeal from the order dated 13/9/2022.
My lord.
Yes.
Delivered by a single judge in WPC number 14046 of 2022. Stop. MSD Mahapatra and counsel appearing for the respondents opposite party number 4 was at the outset submitted that the delay may be condoned, but the appeal be heard expeditiously. Stop. We have also perused the causes assigned for explaining the delay and find that the appellant applicant has made out a case for condoning the delay. Accordingly, the aforementioned delay stands condoned, and the result, this application is allowed. Yes, now.
The matter will be taken up at 2 p.m.
No, he is not informed. He is not informed.
Because there's no noting there. I was looking for the noting. Noting is not there.
No, on mention of my sister, it is.
Now.
Na kehi na
I think he will not oppose the
delay he will have no objection.
Delay will say he will.
We'll take up the matter tomorrow. This will not be fair to him.
We can fix the time also.
The Lord may admit this and for hearing.
No, we are not admitting. Tomorrow it will come up for the fresh admission. We'll hear at that stage only. In view of the order passed in such and such. Let this matter be, let this appeal be listed tomorrow.
My lord, may kindly Thursday. Thursday it can be. Today is
Always.
Thursday.
Thursday. For admission, when there shall be a serious attempt to hear the matter on merit.
Interim order may continue.
Interim order passed earlier shall continue until further orders. 2 p.m. No? You just inform Mr. Mahapatra.
Yes.
Next.
At 2 p.m. this matter will be.
At 2 p.m. I mentioned it.
Item number 31. 31.
None appears.
31. Yes, my lord. Sorry.
Okay.
State is the appellant, my lord.
You should at least
Your lordship has directed that the appeal member.
You should come beside that side.
When you are appealing to the private parties, you should come.
I'm extremely sorry. I will go there.
And that is why I'm going to also designate you.
I'm extremely sorry.
Yes.
This is state is the appellant, my lords. On the last date, your lordship has directed serve the copy of the appeal memo to the advocate who was appearing during the pendency of the writ petition but he refused to take
steps for the alternative.
You can't compel him.
Steps.
Mr. Mohanty Learned Council has stated that last order was passed when?
18th January 2023.
Just a minute. There's a name of some Mr. M.M. Swine. Not a.
M.M. Swine is the junior of Mr. Saktidhar Das.
Oh, so he's not for the.
He's not accepting. He's saying that.
Just a minute, but.
And Haripada Mohanty, your lordship has.
Oh, achha.
Mr. D.K. Mohanty Learned Council, appealing to the appellant, has informed this court when the Dosti was tried to be completed in terms of the order dated 18/1/2023. The Mr. H.P. Mohanty, advocate, has refused to accept the notice on behalf of the respondents.
My lord, sole respondent.
But this order says the others.
Because there's an.
Oh, I'm sorry. That she died and substitution has been carried out.
Because the objection has been filed by respondent number 3. Who's respondent number 3?
Land officer.
That Lakshmi Mohanty was the petitioner and who was the respondent. In the meanwhile, she died on 22nd January 2015 and substitution has been carried out. So her legal heirs are now the respondents.
So one legal heir has filed an objection to delay of 13 days, continuation of delay, and somebody has filed.
Then name of the lawyer may be reflected in the.
That is what I'm saying. That
then on the next date, your lordship can hear the matter.
Wait, let us see. Wakalatnama must be there.
That is not available because no copy has been served on.
No, there's a. How are they not accepting notice? There's a Wakalatnama signed by M.M. Swai, H.K. Behra, S. Biswal, Haripad Mohanty, J. Samal.
Oh, your lordship may note their names in the next.
Names are there. Names are there in the cause title. A cause list, sorry.
Just check up whether the fresh Wakalatnama has been filed.
It is WA.
In WA, Wakalatnama has.
It appears that Mr. M.M. Swai, Mr. S.K. Behra, Mr. S. Biswal, Mr. Haripada Mohanty, and Mr. J. Samal have filed the Wakalatnama for the
legal heirs.
Of
the deceased respondent, Lakshmi Mohanty.
The sole respondents who passed away during the pendency of the appeal.
Filed on 27/2/2018.
Said Vakalatnama was filed.
27/2/2018.
I think this is wrong. This is the old Vakalatnama.
No, this is appeal of the year 2015.
Appeal was it of 2015. If that is filed after
2018.
This said Vakalatnama was filed on 27/2/2018 in WA number 224 of 2015, the present appeal. Right?
Yes.
This is the present appeal. All right. In view of the appearance by filing the Vakalatnama, the service as intended to be made is complete. Mr. Mohanty is requested to serve the copies of the interlocutory applications.
No, only appeal memo. I think there is no appeal memo because I'm sorry, limitation is
13 days they filed the objection.
Okay. But what your lordship has pointed out, one objection is on record filed by one of the legal error.
It is also come to our notice that the objection in this case number 285/2015 has been filed by the. There's some problem.
No, it has been filed. Thereafter, delay has been condoned.
Oh, delay has been condoned.
Yes. On 3/5/2018, delay has been condoned. Then on 9, they have asked for time.
Moreover, the objection to the miscase number 285 of 2015 filed by the appellants. So there is I think, no mention. Who are those opposite parties who are filing this?
My lord,
objection.
3rd July 2018. They have sought for adjournment for filing of counter in the writ appeal.
No, here there is only thing that they have asked for adjournment, no counter and anything. Then on 26/9/2002, there was no appearance.
Then your lordship can fix it to some other date for hearing.
No, but the delay has already been condoned by the order dated 3/5/2018. So therefore, the appeal. So in view of the above observation, the WA 224 of 2015 shall be considered on merit at the stage of admission in the next state. Let the matter be listed on 26 September 2022-23.
Item 32.
Item 32.
It may be served on him.
Item 32 on the board, Mr. Diploma is not being will kindly take this matter up to ministry.
On behalf of
Mr. Diploma.
Dilip Kumar Mahapatra, that line. We had asked for typing it, only one has counted it.
32.
Mr.
What happened to the other case? There was another case, I think.
The request, what is your good name, sir?
Anshuman Pandal.
The request of Mr. Anshuman Pandal and counsel, appearing on instruction of Mr. D.K. Mahapatra and counsel. Let the matter be listed on 14th September 2023. It is made absolutely clear that no further accommodation will be provided by this court, as this is a writ appeal of 2016. You are appearing for the state. Mr. M.K. Kantiel and counsel appears for the state respondents. All right, next.
Item 33.
Yes.
Well, here is a matter of a non-page certified copy. That one week time to file certified copy. And notice has been already served, but he not appealing, my lord.
We are very reluctant to provide any time, Mr. Nath. It is a writ appeal of 2017. Now you are urging before this court to file the certified copy.
Yes, my lord. But notice has been already served. One but the opposite party has not appeared, my lord. The lordship go to the.
Within 3 days, you file the certified copy. At the request of Mr. A. Nath and counsel, appearing for the appellant, let the matter be listed on 26th of September, but the certified copy of the impugned order shall be filed within 3 days from today. Stop. The appellant may also take notice of the limitation that may emerge for the delayed filing of the certified copy. Next.
Item 34.
Table. May appeal.
Yes.
When appeal was filed before by the CISF, challenging the order of Honorable Single Judge under Annexure 1, page 50. And the sole contention of the case is that the particular person who applied to be employed in the CISF, giving the gender as a female, on his activities, he was found that she is not a female, and this medical test report is coming something else, for which, according to the Rule 25, Rule. Let's me come to the page. Rule. The Annexure 6 of the writ petition is real. Rule 25 and 26. For a moment, let's me see. It is. I'm reading my lord this particular things. The rule 25, subclause 2. If during the period of probation, the appointing authority is of the opinion that a member of the force is not fit for permanent appointment, the appointing authority may discharge him or to terminate the service from the force after issue of notice of 1 month or after being giving 1 month's pay in lieu of such notice, or revert him to the rank from which he was promoted to such and such. Here is the case when the authority found that she was given a declaration false, she is not a lady, and she has out of his activities found that to a gender, for which he has 1 month notification given, salary is given, and he has terminated from the service.
What is she?
My lord?
What is she according to you?
My lord, this medical report that is annexure.
How does it come under the suppression?
Because he declared herself.
Yes, according to her knowledge.
According to her knowledge, yes.
Yes.
But his activity and performing his work in the time of training found that I'm just reading, my lord, paragraph 2 of our writ appeal. That it was also informed that the respondent Sanju Behra, on being appointed as a constable female, will be subjected to the provision of CISF and Act and rules, and also other relevant rules or regulations which central government may frame from time to time. The respondent Shano Behra reported to RTC 16 on 16/6/2007. As per sting procedure, physical verification and documentation of the new arrival was carried out by a board of the officers, headed by Mrs. Ruchi Anand, Lady Assistant Commandant. The board of officers, during physical checking and verification of the constable CD females, observe respondents gets it is viewed there unlike that a female. Then
Mr. Pari, central government may have some belief or faith, but we have to go by the circumstances. You sent her to the All India Institute of Medical Sciences and to the Department of Endocrinology, and they say she is suffering from as a case of differential sexual disorder. Can that be treated as a demerit for the service?
My lord, in medical report, paragraph 5, we have explained this particular terminology they have given.
I am reading paragraph 6. After paragraph 5, you have done something Then you have also proceeded further, and that is reflected in paragraph 6.
Yes.
I'll just read paragraph 6, the sentence starting the respondent was referred to the endocrinology OPD of such and such.
Yes.
And their result and opinion. Better ends there. Everything should have a limit. But ask your officers, that is too much. You are living in modern age, not by physical appearance and other thing will be there. You have already, well, judicially, you have created this other sex also. The third category. Where will be they put up according to your recruitment rules?
But here is the case, exceptionally what I am.
No, this doesn't say. The aims also doesn't say. Aims, the finding is there. You come to the page 6 of your memorandum of appeal and paragraph 6.
Yes. According to the matter was referred to the Garrick Department, New Delhi, along with all documents and report. Respondent was sent to the AIIMS New Delhi for further tests. Yes. The respondent was referred to endocrinology OPD and the AIIMS where the respondent was diagnosed as a case of the differential sexual difference.
And how can you say that she is suppressed? Because you are saying after being medically examined, she has been given appointment.
No, my lord.
That
here is the case.
No, we understood. We have given a provisional appointment, yes, subject to the all verifications.
Yes.
Now this is the result of the verification.
Yes.
Does it support your case?
Yes.
No.
Only basing on the medical report or nothing else.
All right. The medical report doesn't support your case. We will be observing that.
Medical report male.
No, there is a provisionally
XX and XYX, just that the medical terminology what they have said. This particular what my
I don't know why is by combination as XY. I will declare my sex as I know, as I perceive. And you have taken to these the obvious text, the test of including to the All India Institute of Medical Sciences. And as a specialist institution, you sent her there. And they say, no, nothing of this other thing. There is a differential sexual disorder means there is some endocrinological disbalances there in the body.
But this medical report, let's say for a moment, see.
All right, sure.
It says disorder. It doesn't say that she is a male.
Yes.
Medical report.
No, Mr. Pari is not saying that he is a male. He says he is not female.
Yes.
That is the problem.
This is the problem. Yes.
Yes.
Does the medical report say that?
No.
Again, it says disorder.
Where is the medical certificate?
This medical certificate in the read petition, my lord. Sorry, my lord. This is read appeal. Nothing in the annex. The read petition I am referring to.
Read appeal is yours and you are saying nothing.
Only
where is the certificate?
Yes.
And
that page 21 onwards. Page in read petition, that is in
your counter affidavit?
we have a counter affidavit.
I think B by 2.
In counter affidavit, page 21 onwards, Mr.
21 is a part of your counter affidavit.
Yes. This counter affidavit
2 copies of medical.
for page 11, Lakshmi Kunti, annexed A by 1.
That is
Yes.
proceedings.
Yes.
Next page 12.
Then the B by 2 is the medical report.
This, it says all the candidates are physically fit. This is nothing to do with
Yes, sir.
your allegation.
It's in page 13, Lakshmi see, the Sanjoga Bera is not female, so Sanjoga Bera should not be treated as a female. Report not treated as a female. This is the report. That's why this authority is forced to give the no. And next, B by 2, page.
Not female.
Yes, Mr. Pari.
Yes, Mela. So this basing on that report of the EMS, let me say the P by 1. Basing on which authority is acted upon, the other documents are relied documents. What is the normal stage? What all these things are there. But this is the final report basing on which the section 20, rule 25, suppose notice has been 1 month salary has been given, and so as
all right.
This is the only issue. But the Honorable Single Judge, who are, even though we have referred all these documents, Honorable Single Judge not considering the same and pass the order.
On the ground that no reasons were disclosed.
Yes.
And you can't supplement it.
Exactly. Obliged.
On the basis of natural justice, Miller. Here the fact is, from the beginning, I am considered to be a girl, and also I was admitted in the school from the beginning. Now the fact is, the part of which they are referring to, after all the medical examination in the recruitment test, I also succeeded. In the training center, when I was in accommodation of other females, my voice appeared to be coarse. That was the complaint of my...
Now you have completed your training.
I have completed my training. So thereafter, they said because of the complaint, we have to be going on the medical test, Miller. And that is the medical report I read that which my lord has referred to. The case is, my lord, there is no, with regard to the genital part, my lord, that is not at all visible. Even from the beginning, even I do not know.
No, that is the page 20.
So now the Honorable Single Judge Miller held, there is no natural justice is ever provided to me. Before passing such order, Miller, no natural justice is maintained.
Yes.
On this whole ground, Miller, they don't have a case. That is the sole ground. And to that, Miller, they don't have any answer to that. Even, my lord, under annexure, the annexure they are referring to 3/2, Miller, where they have they ever explained as to whether they have provided the natural justice, asking me what is what. So all that examination they have done in their level, Miller, that is not the final finality in their in this subject.
And
they have taken it. But the theory which I am suffering, there may be variation of the medical report. It may be referred to a medical board with regard to their concern.
All right, Mr. Mohanty. No, so you have heard you sufficiently.
But there only one point I am clarifying, ma'am.
Yes.
With regard to the giving opportunity of hearing all these things, they are natural justice they are saying. The rule is very clear. Either to give notice or, that means very language is, after issuance of the notice of 1 month or after giving 1 month stay,
considered her sexual profiles, and that is the reason for termination. So the duty of the court is to lift the veil. That's all. Heard Mr. P.K. Pari, the Deputy Solicitor General of India, appearing for the appellant. So by means of this intercourt appeal, the order dated 25/4/2019 passed by the single judge in WPC number 6580 of 2008 has been challenged. Stop. The facts are mostly admitted. Even the respondent did not deny the verification of her gender status was carried out in different levels by the experts. Stop. The respondent was selected as the female constable under the Central Industrial Security Force, in short CIF, and she was given the appointment and put to appointment and placed under provision. While the respondent was undergoing training during her provision, she was issued the termination order dated 15/11/2007, Annexure 6 to the writ petition. Stop. Before issuance of the termination order, in lieu of notice, 1 month's salary was given. This stops. The same termination letter was challenged in the writ petition as above stated. When a single judge, while examining the process, has observed that the reason for termination, since was not disclosed, the said order of termination is unsustainable. Stop. Having referred to the celebrated decision of the Apex Court in Mohinder Singh Gill versus the Chief Election Commissioner, New Delhi, area 1978 SC 851. Where a single judge has observed that a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of the affidavit or otherwise. Stop. Otherwise, an order read in the beginning by time it comes to court on account of a challenge, get validated by additional grounds later brought out. Stop. Mohinder Singh Gill Sopra was referred only for the purpose. Yes, the appellant filed an affidavit by providing the grounds for termination. In short, the out of the ground which has been emphasized by the appellants in their counter affidavit is that according to the one medical test, it was found that the respondent doesn't belong to that female category, and as such, she was unfit to be appointed as female constable. In the appellants in their counter affidavit as in this regard stated that is relied on a medical opinion of the director within the medical CIF which is reproduced hereunder. After carefully going through all the medical documents / investigations, opinion of MGM Medical College, MY Hospital Indore / AIMS / Dr. Mrs. Pushpa Rao, gynecologist, CACRPF, New Delhi, I am of the opinion that Sanju Mehra is a male underdeveloped and not female. As informed to Sanju Mehra by AIMS specialist that the Sanju Mehra's future sex of rearing will be male, which will need testosterone replacement. No, the same. Testosterone replacement, a multiple stage surgery for correction of genitalia stuff. Is where is the name is coming? Make the plan and make the respondent name without this respondent. So what? Mr. Pari.
Yes, ma'am.
No. Learn. Sorry. DSGI has also referred to the opinion of the All India Institute of Medical Sciences from the writ appeal. Since the opinion of the All India Institute of Medical Science has been extracted by the appellants, we'd also like to refer that part as understood by them. Stop quote. The respondents was referred to endocrinology OPD of AIMS, but the respondents was diagnosed as a case of differential sexual disorder, this underlying stuff. There cannot be any dispute. All the considerations were made by the appellants behind the back of the respondent. The consideration of these materials without the knowledge of the petitioner cannot be treated bona fide, and as such, the court has to lift the veil and find out what prompted the appellants to terminate the respondent. According to us, the order of termination is not a simpliciter one. And that was also not passed on assessment of performance of the respondent by determining the provision. Stop. So far as the disclosing the ground is concerned, if the disclosure is not made at the time of passing the order which provides the cause of action, the reasons for passing the such order by way of counter affidavit as a matter of the afterthought cannot be accepted by court. Therefore, we do not find any infirmity in the order of the learned single judge. But what has shocked us, the way the respondents has been treated by the appellants. It is apparent that she was not aware of a differential sexual disorder. Stop. Even from the opinion as accepted by the appellants, it shows that it is a developing profile, and it is well established in endocrinology. The endocrinology profile changes with the growth of person. What remains dormant in some stage may be dominant in some other stage. What we are mentioning all these materials only because of that, to find out whether there was any deliberate suppression. Answer must be in the negative. And it says, even the termination order cannot be justified by so-called allegations of purported, the allegation of suppression of the gender status of the respondent. Whereas, next paragraph, empathy was required, but the respondents has shockingly terminated the petition. As such, we affirm the judgment of the learned single judge. The respondents, however, may take a decision in respect of a posting, etc., in the public interest. The result, the appeal is dismissed. There shall be no arrest to cost.
Item 37.
My lord, along with me, Miss Babita Sound, I may be replying. Obliged, ma'am.
Item number 37, my lord, on behalf of Mr. A. Misra. My lordship, I pray for kindly grant me one to file death charge, written note of submission and death charge.
This is up to you. Let the matter be listed on 26th of September. Your name? Your name?
Niraj Kumar Singh.
Roasted Mr. Niraj Kumar Singh, learning counsel, appeared on instruction of Mr. N. Mr. D.K. Mohanty, learning counsel, government advocate appears for the state of respondents. Next.
39.
Milord, I am appealing for the respondent.
Yes.
In this case, it is a compassionate appointment matter.
I remember.
2019, your lordship allowed the petition directed to the appointment. Now,
Yes.
Milord, your lordship kindly see, along with the writ appeal, Milord, limitation petition was not. Item 37, I am. Milord, the writ appeal was filed.
I understand, but they on the request you did not pose the prayer for adjournment. He was making the prayer for adjournment.
Milord, that's why it is a compassionate appointment. 4 years.
I know that we heard you, counsel. I still remember, but they want to file some notes and other things. They
Let them file, Milord. A short date may be given. There is also another point for problem, Milord. The appeal is not accompanied by the limitation petition, which was filed behind the.
All right, take all the issues and the matter will be taken up.
But your lordship will be short adjournment, a date may be fixed.
8th of September.
Well,
Huh?
8th of September.
It will come on 8th of September.
Item 39.
Madam, I'm a custodian of this project. As directed, I'm submitting my report
Yes.
today. The work has been delayed because the first contractor,
Yes.
the lowest bidder who has got the order, he could not do the work, my lord. And now the work has been transferred to RATHO. They are taking up the work in work putting manner. The last date of completion was December 15th, December 2022. Now they are saying that the work will be completed by end of March, my lord.
End of March.
End of March 23.
24.
24.
Who is appearing for the what?
Yes, my lords, I am appearing for Watco, my lords, of which you now 6.
Have you got a copy of this report?
No.
I know, I have just given.
Just give him because
May I also pay for a copy, my lords? No, my lords,
no, your chief executive officer has assured the MIPAS that it will be completed, entire project will be completed by 31st of March 2024.
Yes, my lords. We have discussed and they have committed that it can be completed by March because
They have also assured that water working problem of this Kotak city will not be there before the monsoon 2024.
There is a
May I invite my lord's kind attention, please? With due permission,
I assure you.
Your lordship, I may be pardoned to appear through BC, your lordship.
What happened in this rainy season?
Your lordship, the conditions of road are completely worthless, and because of the Excidal Act of authorities, 2 persons has been died in the open drain, your lordship, in last month only.
Mr. I for the Court of Municipal Corporation.
Yes. Your lordship, I am a court copy.
Just a minute.
My lords, I was supposed to actually file an affidavit today. I'll pray for some time.
But I think already twice you've taken time.
No, my lords. Last
Before
affidavit.
that was an order. That was
Last affidavit was served earlier. My lords are directed on 4th/8th. Now I was.
There were two aspects of the matter.
My lords.
First of all, the drainage and sewerage system.
Yeah.
Right.
My lord.
This may not be now under your control.
My lords.
What about the road?
Roads are there. My lords, I am.
As Mr. Pari is pointing out.
My lords.
The road is in your control.
My lords.
When the road's condition will be improved.
My lords, I'll file an affidavit. I'll just require about 10 days time.
So because of this water on the roads, also the roads get damaged.
Control roads are controlled by 4 departments. One is corporations,
another
then irrigation.
But
may I humbly pray your lordship.
But with you, no?
Now, what are you doing about draining that excess water?
No, my lord, this actually after the drain is over and having 5 complete stations having 20 gates, I have written that even in a high flood and in more rainfall, there will be no water logging.
No, water logging in the drain, but there are some low-lying areas where there is water.
There will not be there.
How?
That sewerage system, that sewerage system that is now being built will take the water away from wherever it is now getting locked.
Even from land.
Even from land. That's because now what is happening, all the wastewater.
Pumps. That is
Hydraulic pumps, the design, have you checked of the design of the hydraulic?
Yes, that's I've written, there will be no change of hydraulic design.
All right.
May I humbly submit your lordship one?
I have discussed with the all stakeholders. After the work is completed, if they take it last, they have delayed about 9 months. If they take it in work fitting work, then everything will be all right, man.
All right.
But this, I personally request this government monitor at least once in 2 months so that work will be completed. Otherwise, they will say,
I understand that will do.
Lordship, in fact, your lordship, on earlier occasion, there was a direction from this honorable court to visit combinedly, that is the member of
now
court commissioner.
Rain has gone now. If you visit, what will you see?
The thing is that your lordship, the roads in the CDA, roads communicating from Sati Chaura Chowk to the end of Bakshi Bazaar, and the roads from both the ring roads, as well as garbage, cleaning of garbage, all are not in a proper condition, your lordship. Moreover, we have given more reports, your lordship. They have not complied that. Again, this honorable court has been pleased to direct the city engineer to accompany that team, but they have deputed their subordinate engineer to accompany us. They came by a car. In the streets, it was another problem, your lordship.
All right, first of all, let us hear from this Court of Municipal Corporation.
Lordship.
My lords, let me, this is what my.
May not be. Will not be. May not be. Just read the last page. Everywhere may not.
It's an expectation of. Also,
May I pray, my lords, one thing? My lord, I am going to call all of them for a meeting. I'll discuss with them. My lord,
14th next month.
14, my lords.
Yes.
My lords.
Any request to Mr. Devashish Naik, the council appearing to the Court of Municipal Corporation, let the matter be listed on 14th September 2023. Today, Mr. Michael Security has filed a status report on box 3. For purpose of reference, the relevant part of the said report is extracted below. You start from here. Complete here.
Lordship, may I further humbly request your lordship with due permission?
But wait, 14th will take up the matter again next month. Then you will record your submission.
Lordship,
In
I
the
was of the
meanwhile-
opinion that in the meantime, in the event, there was a joint visit to all the area which the.
Just wait, let me complete the order.
Lordship, obliged to you, Lordship.
In the meanwhile, the Court of Municipal Corporation shall file their affidavit in terms of our order dated in terms for the affidavit, particularly on coordination of the drainage and the road construction. We would also request Mr. Naik, Learned Counsel for the Corporation, to convene a meeting of all the stakeholders to make the affidavit a comprehensive one. Stop. Mr. Mr. P.K. Bhuyal, Learned Counsel.
Yes, I have also submitted my affidavit to that Milords for Watco Milords.
Has stated that the Watco has also submitted their affidavit, but unfortunately, but that is not on record. They will still compile the affidavit in the records. Stop. You have got the compilation from our registry?
Yes, ma'am.
All right. That's all for the time.
May I pray for a copy of this order, my lords?
The copy of this order be furnished to Mr. D. Naik, Council again to the Court of Municipal Corporation. The other matters date will be given.
So, Lordship, I may be pardoned to make a mention, please. Item 14, the next matter, I am the petitioner, so I am appearing person. So, Lordship, this is a matter arising out of the recruitment of the residing officers in the DRTs. It's a 4-year term. In the meantime, 2.5 years has lapsed. After 6 months, this matter is being listed, Your Lordship. May I pray that let it matter will come tomorrow, Your Lordship?
Day after tomorrow it will come.
Yes, sir.
Listed day after tomorrow.
My lord, I am pardon. Item 63 is a PIL relating to the promotion of the candidates services. Notice has been issued. The state has not filed counter. State will be filed somewhere.
My lord, we will intervene in the matter.
There is some intervention application.
State will be directed to file the counter.
8th of September 2023. In the meanwhile, the state opposite party shall invariably file their counter affidavit.
Let's item 59. Introduction continued. 43 to 59. That's
59. There is order first in this parliament. Is it day?
Name, please.
26. On this part. Will continue.
Same prayer in item 61 and 69.
My lord, item 75 will be kindly taken up tomorrow.
Tomorrow is not necessary. Now, tomorrow. That is 6.
Let 65. Let it come tomorrow.
No, it will come day after tomorrow. Let us see.
Oh, please.
That's admission item number 1.
The council is here, Malad. I contacted him and he has come. served a copy.
My lord, I don't have any instruction. I have to take it.
No, no, only liberty will be granted. Your lordship wanted to dispose of the matter with the observation.
Your lordship, after hearing both the parties, your lordship has passed the order.
Yes.
And this is the order, my lord. And for last, from the day one, he is not, after 97 harassing like anything, my lord. Not providing the center.
Without instruction, you can say all those things.
Because I was conducting counsel. From the very beginning, I was there. I am not.
So here actually, if your lordship looks at the background of the case,
yes,
as my friend says that the wife has been harassed, the husband has been tortured, not harassed. But forget that matter. But question arises here. Actually, I would like to place before your lordship that since those documents were not before your lordship at the time when the order was taken passed and the matter was taken for hearing, though it was filed, I'm told. So that is the reason your lordship asked me the other day, you want modification of the order regarding reduction of the amount. Then it is open for me to move the trial court and move an application for modification. But since your lordship has passed an order, it will not be possible for the court to also consider those things. Therefore, lordship wanted, but in the presence of the other side.
I remember, I mentioned also the section.
Right. So liberty will be granted me to move the trial court. And
liberty is always granted, but the apprehension of the petitioner is that since we have passed the order, the family court will be a little reluctant to exercise the jurisdiction. So we'll dispose of the matter.
When the matter was taken up, my lord, everything was taken into consideration.
Mr. Khuntia, perhaps you are thinking that lordship is interfering. No, please appreciate that.
We are not touching our order. Just give the Hindu Marriage Act if they are not. You read section 25, subsection 2 of Hindu Marriage Act. There is a statutory provision. His apprehension that since the order has been passed by the High Court, family court may be reluctant to exercise their jurisdiction.
So
let us find out. It's very slow. Sorry. (25) is a provision very akin to section 125 of the Code of
125.
Right. It says that with the change of the circumstances, anybody can approach the court seeking modification in the.
In section 124 provides that. There is a specific subclause.
No, there is section 124 also is there. So these are all the similar provision. But since we are concerned with the Hindu Marriage Act, I'm just reading for you benefit.
25.
Subsection 2. That if the court is satisfied that there is a change in the circumstances of the either party at any time after it has made an order under subsection 1, it may at the instance of either party vary, modify or rescind any such order in such manner as the court may deem just.
Right.
It is always there. It is open, perennially open. We only observe since our order is there, but the family court will be just in passing such order under section 52. That will be the order.
It will not stand in the way. So
they will be at liberty to exercise their jurisdiction. This order has been passed by the High Court.
He has to pass independent order.
Because this is a margin doctrine will come. So it will be the ultimately the where you go for the execution, go to the family court. So that will be making clear.
Right.
Heard Mr. S.P. Mishra Senior counsel, Mr. D. Panigrahi, and counsel for the review petitioner. By means of this review petition, the petitioner has sought to review the order dated 3/8/2022 as passed by this court in matter number 102 of 2014 for change of circumstances. Stop. We have also, should I record your name because you have no instruction?
Yes, exactly.
All right.
If you don't request, I have.
All right. Mr. J.K. Kuntial and it counsel has also appeared for the respondents in this petition. So this petition is disposed of with the observation that even though the order has been passed by this court, order dated 3/8/2020, passed by this court, the judge family court will have the jurisdiction to vary, modify, or rescind any such order in terms of Section 25 within bracket 2 of the Hindu Marriage Act 1955. Stop. We make it abundantly clear. The jurisdiction under Section 25(2) of the Hindu Marriage Act can only be exercised if there is a change in the circumstances of either of the party at any time after it has been made an order at any time. Stop. Accordingly, this review petition stands disposed of.
Item number 2. Item 2.
With the pro forma respondent number 3.
Okay.
So I don't know. Old matters we have a records also, only I got this copy.
It is reported to us that one of the leading counsel has been elevated at the judge. Keeping that in view, released this matter on 31/8/2023. Meanwhile, the appellant shall engage the new counsel or appear appear themselves or through their authorized agent. It is also made clear that if on the next date there is no representation, this court will be persuaded to pass an order for non-prosecution. Mr. P.K. Pari, Deputy Solicitor General of India, has appeared for pro forma respondent number 3. Release this matter on 31st of August.